hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
And good morning. Welcome to the February 6, 2025 sitting of the Massachusetts Appeals Court. Let me introduce our panel for today. Sitting to my right is Justice Suk-Young Shin, to my left, Justice Chauncey Wood, and I'm Justice Eric Neyman. We have 6 cases on today. Usual appeals court rules are in effect, which means each side has 15 minutes to make its presentation. There is no rebuttal. I assure you that the judges have read the record. We have read your briefs. We are familiar with the facts, so we urge you to cut to the heart of your best argument. However, your 15 minutes is yours to use as you see fit. One final note before we begin, you will see the judges on occasion looking down at their notes and at their iPads. I assure you we are not reading the funny pages. We are simply checking your representations on the record in real time. With that in mind, let me check with my colleagues. Any other housekeeping? Seeing none, we'll call the first case. Docket 24P258, I hope I'm pronouncing this correctly, Commonwealth v. ADEBOWALE. And we'll hear first from Attorney Gleason. Did I get the pronunciation correct?
I believe you did, Judge.
Wonderful.
Good morning, Your Honors. Attorney Thomas Gleason for the defendant. As Your Honors are aware, the nature of this appeal is a challenge to 2 decisions on motions made, one a pretrial motion, one made at trial. Pretrial motion, a McCarthy motion, dealt with the issue of whether or not there was sufficient probable cause for the arrest of the defendant. And the second issue dealt with a request for a directed verdict and whether there was sufficient evidence to convict, even looking at the light most favorable to the Commonwealth. I think it's productive to focus more on the directed verdict, although the issues with respect to both motions are quite similar, but of course there is a difference. First of all, I think that it's important to note that the overall factual situation here, the context of this, and this is a situation where apparently there was evidence that there was a very sophisticated, multi-layered, fraudulent scheme to defraud people of money involving numerous victims. In terms of this case, we're not dealing specifically with that overall scheme. We're dealing with one particular alleged victim and what happened to her, and actually one aspect of what it is that happened to her, because there were a number of different funds that she transferred to in this criminal enterprise. Essentially, what happened is that she made contact with a person representing themselves as James Deere. As a result of that conduct, on December 27th, 2018, she deposited approximately $75,000 into a SunTrust bank to the account of a Jerobi Corporation, and those funds were shortly thereafter withdrawn. I believe it was on the 31st of December of 2018.
So let's cut to the heart of your argument. You focus, I understand you make a number of different arguments, but much of your focus is that the evidence was insufficient to demonstrate the defendant's knowledge or intent.
Right.
With respect to the money laundering, the statute provides that the defendant, that the money was known to be derived from criminal activity, or which a reasonable person would believe to be derived from criminal activity. Why was the reasonable person standard not met here, particularly in light of the evidence of your client making, I want to say over 45 days, something like dozens of withdrawals in $500 and $3,000 increments from several different ATMs, including multiple withdrawals each day, combined with him arguably setting up the account, using the name of, is it John Richards, getting his driver's license immediately before. I'm not going to go through all of the facts, but why is that circumstantial evidence insufficient to meet the reasonable person standard?
Well, I think, Judge, that there's a number of things that you suggested. For example, setting up the account that are subject to question here. Just going through, essentially, Judge, is that there's no evidence that, no evidence presented nor claim that this defendant was James Deere, and that he was involved in the negotiation of the initial illegal transaction. I don't think that was the Commonwealth's case, and I don't think that there's any evidence of any contact between him and James Deere or the alleged victim.
Yeah, but there was evidence that he opened the account.
Well, that's the question, Judge, that needs to be looked at, because I think the issue here is, and where the defense sees a missing link is in the string of inferences that are being, the Commonwealth is asking the jury to make is it's not really whether or not this defendant had any contact with the alleged victim or the original scheme. It's what is his relationship with the Jerobi account.
Sure, but do you dispute that a jury could find reasonably, based on the evidence, that he opened the account?
Yes. And I think
you do dispute that a jury could reasonably have found
Under
that?
the Lattimore standard.
Yes.
You're saying.
Yes, I do. And the reason why, judges, if you look at it is first of all, is he doesn't open an account. There's actually no dispute about that. Jerobi opens an account.
Right, but
and
sorry.
I think there's a difference.
I don't mean to be difficult, but there was a video, there's ATM, there's surveillance photographs showing him being in the bank at the time the account was opened.
Yes.
Right, okay. So is this a semantic distinction? He opened the account perhaps posing as someone else. That's the evidence that the jury could reasonably conclude that he opened the account perhaps posing as someone else.
Well, I think, Judge, that's the real nub of the issue is the word perhaps. I think if you look at all of the facts is that the jury was presented with who incorporated the Jerobi account. And it was this person named Robert Richards. And there was no evidence, at least in terms of opening the account, that it was done by this defendant. In terms of opening the bank account, the evidence is, you're quite correct, Judge, as I understand it, is that he was in the bank at the time. But the documentation relative to the opening of the account is it's signed by a John Roberts Richards, president of the corporation. Now, there was no evidence presented as to that transaction and description of the person that was involved in that transaction or anything about that. There's a name of an employee of the bank that's on that transaction, but the evidence, there's no evidence from that person. And presumably, one of the things that the judge could, what the jury could infer is that when somebody's setting up a bank account, they have to produce some type of identification. And there's no evidence here of, the only evidence, I suggest, the only evidence that you have that he set up the Jerobi Corporation is that he's in the bank at the time. And that he's
and it's set up in the name of John R. Richards or John Roberts Richards.
Right.
Who magically has the same address as your client in Florida at the place where he established residency a half mile from the bank.
Well, Judge, if you
and
look
that's
at
where the money was sent to as well, to that same address.
What you look at there, Judge, is ask you to look at is that, first of all, in the corporation papers, there's another address that's given for the corporation. And what you have is you have evidence that's presented to the jury that a check was sent, a 59, from another, relative to another alleged victim, is sent to an address that he lists on his driver's license. So I understand that, Judge. But if you look at it, the check is...
Which he sets up right around the time that the fraud is beginning as well.
That he sets up what? The corporation?
The driver's license.
Yes. Yes, the dates are close, Judge. But if you look at it, the check is addressed, made payable to the corporation. The check is addressed to the corporation, not to him. And then if you further look at the documentation in terms of when you look at, how is this delivered, it's signed for, there's no signature, but it's allegedly signed for by Mr. Richards or Mr. Richards Roberts.
Yeah, but there's no dispute it's sent to the defendant's house.
There's no dispute that it's sent to the residence where he has on his driver's license.
Right, and there's also no dispute that on the day that it was deposited, that same check was deposited, the defendant was again in the bank.
Yes.
Okay.
But the other thing, Judge, is
Supporting an inference that he was the one who received the check and he's the one who deposited the check, a reasonable inference.
well, that's the issue, Judge. How I look at it, how the defense looks at it is that can the jury make an inference? And I would suggest that the jury can. But the jury also has to weigh inferences. And as the court is well aware, the jury is instructed, I'm not sure in this case, but the jury is instructed that, you know, if you're weighing inferences and inferences are relatively likely, you're bound to accept the one that leads to a path to innocence. So the issue is not, can they make an inference? Is it reasonable inference under the circumstances? Is it reasonable for the jury to jump and conclude that he's this Mr. Roberts Richards? And the reason why that's important, Judge, and why it's subject to dispute is the evidence is replete here, is that there's somebody else, at least one other person involved in this. Your Honor mentioned the cash withdrawals, that he made a lot of cash withdrawals. He did. Apparently, the evidence is that he made 24 of them, and he made those on surveillance. They were photographs. I went through the records, Judge. I looked at the bank account statements. There's 2 of them. There were 50 cash withdrawals.
Right. But there's a theme running through your argument that I struggle with, which is this suggestion that he didn't do everything. Okay, so somebody else did some things, and there's a co-defendant in the case. But why can't it be, I keep thinking to myself, right, so joint venture. So he doesn't have to be guilty. The jury doesn't have to conclude that he did every single thing, but only that he did things that furthered the joint venture knowingly, right?
Right.
And so what do you accomplish by proving, if you did, or raising a reasonable doubt about the fact that other people took out money, when he clearly took out a lot of money?
Well, Judge, if you look at the money that he took out relative to the amount of money that went into the account, it's really on the minimal side. He's taking out $800, $200, and some $1,000 or more actual withdrawals at the bank counter. But if you look at if you look at the rest of the account, all of the criminal acts involved really the wire transfers. The wire transfers coming into the account, the wire transfers going out of the account. There is no evidence that he was involved in the wire transfers. It's not his bank account. It is the bank account of a corporation. Now, is he involved with the corporation in some manner? Yes, he is. Because at the very least, he gets a check for the corporation sent to where he claims his residence is. We don't know anything else about this Mr. Roberts Richards. What we do know is there's evidence, direct evidence, that he wasn't the one that received the check for the corporation. And then what you have is his bank account activity, where the bank records clearly state this is a corporate account set up by Mr. Richard Roberts.
The Commonwealth says, I'm sorry to interrupt, but the Commonwealth says, and this is at footnote 26 of their brief, that there was evidence that the defendant received a check payable to John Richards, in quotes, the name of the purported CEO of Jorobrai, at his home address, and deposited the same into the Jorobrai or Jorobori account the same day, citing record volume 1, page 27. Are you saying that's incorrect?
I'm saying, Judge, that could the jury make that inference? Okay, and as I indicated, I'm not going to stand here and say that they couldn't make that inference, but it's a matter of weighing the inferences. They are required, the jury is required, if there's another reference that can be made that is equally as plausible, then they're required to find him not guilty. They're required to go towards innocence.
Well, juries are routinely instructed, and our case law is clear, that inferences drawn must be reasonable, impossible, not necessary or inescapable.
Right.
So I come back to the same question. Why is that not a reasonable, possible inference here?
It's not reasonable and possible in terms of the context of which they're making it. Because there is another person involved, at least one other person involved in this, who has more control over the bank account and more activity in the bank account, and all of the activity in the bank account is the direct criminal matters that are occurring relative to these alleged victims.
So I I don't want to suggest that the burden never shifts to the defendant by asking this question. Of course it doesn't. But I'm pondering how he could be an innocent dupe. These were your words. You repeatedly said he was an innocent dupe, or if you wrote the brief. And so I'm trying to understand, without speculating and without shifting the burden, what that could mean. And I couldn't come up with anything. In other words, this jurobry seemed to be created for the sole purpose, according to the evidence. The only reasonable inference I could come up with was that the entire point of this account was to be a funnel for the romance scheme funds that kept coming in from all over the place and then wired to foreign accounts. I don't understand what role he could possibly think he would be playing other than facilitating the scheme.
Well, Judge, if you look at it from the perspective of it's a corporate account, there is evidence that someone else set up the corporation and the corporate account. You have documents from the bank, Judge, that it's another person. And then you look at it also from the perspective of is, if there's 50 cash withdrawals and he only has 24, where are the photographs of the other 26? And who is it? Is it one person? Is it more than one person? He's not involved in the wire transfers for the major amounts of money, whether it's into the account or out of the account. So what you're left with is you're left with somebody who has access to a corporate account, makes cash withdrawals from the corporate account. There's somebody else or some other person that has major, more significant control over the account. And how do you infer when there's no link between him and the actual conduct that's taking place, the fraud, the actual fraud? How do you conclude, where is it that he somehow knows about it? How does he know about it?
I see the red light is on, but let me just check with my colleagues. Anything further? Nope. We understand your argument. Thank you very much.
Thank you.
We'll now hear from the Commonwealth.
Good morning. May it please the court. Kristen Jang for the Commonwealth. And like my brother, I think I'm going to focus on the second issue presented here, the Latmore issue. And I think in the light most favorable to the Commonwealth, as the standard requires us to apply, I think it's very reasonable for the jury to have inferred that the Jurobry Corporation was established not to conduct legitimate business, but to hold the proceeds of some sort of overall fraudulent scheme. And that the jury could have further inferred the defendant's knowledge of this and intent to participate. And I think the strongest evidence of that is that check that was pointed out during my brother's argument from a different victim that was made payable to John Richards, who was the purported CEO of this corporation. It was sent to the defendant's residential address, and then it was deposited into the account that same day. I think that's extremely strong evidence that of the defendant's connection to this corporation, along with all the evidence of the consistent pattern of cash withdrawals from different branch locations and different amounts throughout this about 45-day period that the account was opened before it was closed due to fraudulent activity. And I think
there was evidence that the defendant lived at that address. Was there any evidence put in at trial that he lived there alone?
No, there was no evidence of that, no. But at the same time, that's the Latmore standard. We have to look at everything in the light most favorable to the Commonwealth. The Commonwealth was not required to prove that the defendant knew all the details of the scheme. And at its core, participation can take the form of an agreement to be available to assist in the commission of the crime. And that agreement doesn't need to be formal or explicit. There's lots of case law on that. And also, the Commonwealth was not required to prove that the defendant was this James Deere person, nor did the Commonwealth attempt to do that. I think it was, there just was no evidence of that. But at the same time, evidence of a joint venture is sufficient to impute the acts of whoever this James Deere person was onto the defendant. And also, I would like to point out that the defendant didn't present a mistaken belief defense at trial. That was not argued. It was just sort of a sufficiency argument, to my knowledge. So the defendant didn't testify or produce any other evidence to support that.
I have a question about the money laundering conviction. Yes. I'm looking at the elements that you articulated, page 39 of your brief, and I think that the Massachusetts money laundering statute is different than federal money laundering in a surprising way, that there's no requirement of concealing it.
Correct.
Has anybody ever challenged that notion that our money laundering statute doesn't require concealment?
No, and I actually made a fatal mistake when I was drafting this brief. Unfortunately, I had a whole nother version of the completely wrong paragraph of the statute. And I had to rewrite it because there are no published cases on this portion of the statute. So, I had to draw from other areas of the law as a comparison, but no, no one's really challenged it.
And it seems that the most important element is the third, that the funds be known to be derived from criminal activity or which a reasonable person would believe to be derived from criminal activity. So I guess Mr. ADEBOWALE the jury has to find that he knew that these funds, but then in other words, what we know is that, well, he's present when one check is in the bank, when one check is deposited. We don't know that he has anything to do, there's no evidence that he has anything to do with wiring the funds out into the world, but he takes funds for himself in an ATM. Am I right about the state of the record?
That's correct, but there's also evidence, and there's a reason, you can make a reasonable inference that he also opened the account. So I think that's the strongest on this particular element, the fact that he created the circumstances so that all these funds could be deposited and then wired out.
Okay, thank you.
Sure.
With respect to the first element of the money laundering statute, it requires proof that the defendant directed, organized, financed, planned, managed, supervised, or controlled
Yes.
the transportation or transactions at issue. Which one of those do you say the Commonwealth established at trial?
I would say organized and financed as to opening the account itself so that there was a mechanism for all these funds to be deposited. And then directed, managed, and controlled goes to his withdrawals from the account and also the deposit of that check that went to his home.
But so, I'm just struggling with this. In other words, he doesn't have to, he could just be getting the funds as payment, like his weekly paycheck from the scheme, let's just say he's a bit player in this thing. It feels like the reasonable inference I'm struggling to get is that these couple $100 ATM withdrawals are payments or, salary or something, I don't know. Feels like speculation. But that assuming he did that satisfies the money laundering statute. He's not concealing the money in any way.
There is no requirement of concealing. He just has to make sort of some transaction or transport it.
He opened the account. I agree, reasonable inference that he opened the account, and then he takes money out of the account for himself. That satisfies the statute.
According to how the statute is written, yes. I think it also helps here, it's in this case because of the nature of the withdrawals, the fact that he went to different branch locations. So I think some of the elements of concealment are met here, even though that's not really what the statute that was at play. But in that other version of the brief I wrote, we definitely met a lot of those concealment elements of that other paragraph of the statute.
Concealment's only required for subsection 2 of section 2, correct?
Correct.
So it's an alternative way to prove it, but it's not required even in subsection 2, correct?
I think that's correct.
Can you shed any insight as to why this case was charged only under section 3 as opposed to 1 or 2?
I don't. I apologize.
No, I was just interested. Thank you.
And if there are no further questions, I'm happy to rest on my brief.
Seeing none, thank you both. Very interesting
very
case. The case is submitted. Calling our next case, docket 24P480, Commonwealth v. It's either Clement or Clemente. And before we begin, I would remind counsel that this case is partially impounded, so please refrain from referring to any impounded materials at argument. Okay?
Thank you. Good morning, and may it please the court. Caroline Howe on behalf of Mr. Julius Clemente. There are 3 issues before the court today.
We have to ask you to speak up a little bit, please.
Of course. There are 3 issues before the court today, and I would like to focus on the sufficiency issue first, concerning Mr. Clemente's lack of intent to distribute. 4 grams of fentanyl were found in bedroom 3, which belonged to Mr. Clemente, but there was no other reliable evidence of his specific intent to distribute. And that's because there was no indicia of distribution present in that room. The amount was equally consistent with personal use, according to the Commonwealth's own expert, who testified that that amount could be consumed in a matter of hours or days. The fentanyl was found in one baggie, not packaged individually for distribution.
Why is the Commonwealth limited to what's in that bedroom?
So I think it's looking at the evidence of the sister's bedroom, bedroom 2. So in that bedroom was her passport, her belongings, her mail, her sanitary items, her trophies. And all of these items were not just in a separate room with all of her belongings. It was deadbolted. It wasn't locked like a typical bedroom door. There was a deadbolt. And there was no key to that deadbolt on Mr. Clemente or anywhere else in his home, so there was no way for him to access it. He was the only one home at the time of the execution of the search warrant. So when we look at cases like Commonwealth v. Rivera, Commonwealth v. Schmieder, where it's not charged as a joint venture, we have to look for evidence supporting constructive possession. Can he exercise control over the items in that second bedroom? And the great weight of the evidence suggests that there's no proper inference that he can. And it's because of that deadbolt, it's because of all the evidence that those items don't belong to him. So essentially, given the
The Commonwealth had to put in evidence that he could have accessed that bedroom. Is that what you're arguing?
Yes, I think where the room is deadbolted and where it clearly belongs to somebody else, they have to show evidence that he could exercise control over those items that would typically be used as items of distribution.
Okay, so the expert said that 4 grams of fentanyl could be consumed by someone in a couple days, something like that. But his testimony also establishes that amount of fentanyl is worth $800, right? And then you have an admission from the defendant that he wasn't working at the time. Why isn't it reasonable to infer that he would not have $800 available for personal use, or $800 of fentanyl available for personal use?
So I don't think that the expert testifies that the 4 grams of fentanyl found in Mr. Clemente's room are worth $800. It's the amount is less than half a finger of fentanyl, and that amount, I believe, according to the testimony, is worth about $150 to $200, or maybe $200 to $300, and that's, I think, on the transcript for page 114. But even so, I think that there was evidence that Mr. Clemente, used drugs. He was a drug user, and so I think depending on the severity of somebody's, drug use, that that amount could be used, according to the expert, in a manner of hours or days. But just because Mr. Clemente wasn't employed and wasn't filing taxes doesn't mean that he wasn't getting support from, say, his mother. So I don't think that that is enough to conclude that he must have been intending to distribute the 4 grams of fentanyl found in his room.
Well, must have is not the standard, right?
Of course not. But I certainly think that there's not enough for the Commonwealth to meet their standard on that basis that he intended to distribute the 4 grams. And so what that leaves the Commonwealth with are the 2 prior convictions from 2018. And because those cases are both so dissimilar from the facts of this case and so remote in time, they also are not probative of his intent and cannot supply the missing and cannot render the evidence sufficient here. And on that point, I think Commonwealth v. Goldman is really instructive.
My question for you is, how would you distinguish Goldman?
Of course. So I think that in Goldman, you have both substantially similar facts between the 2 prior convictions and the present case, and they are remarkably close in time.
Okay, so remarkably close in time is, I think, within 2 weeks of the prior, 2 or 3 weeks of the prior convictions.
I believe 6 and 10 weeks for the 2 prior convictions, but there's also an overarching conspiracy of intent to distribute cocaine that ends 2 weeks before the present case.
So what are the facts that are so particular in that case that they were admissible? It's that he did street-level drug dealing from different locations with a woman present and sold 8 balls. Am I leaving anything out?
No, I don't believe so. So, I mean, I think what we see from cases
I was
like-
actually surprised to read Goldman and see that that's existing law, but it is.
Yes.
So.
But I think we can also look to other cases, like Commonwealth v. Healthfant, Cater, Sharp. In these cases,
Well, get back to my question
Oh, yeah.
first. How would you distinguish Goldman? Is it just, so the time is 6 to 10 weeks versus 3 years? How else do you distinguish it?
I mean, I think that those fact patterns are remarkably similar. You have somebody changing their location. You have somebody bringing a female accomplice every time and selling the exact same amount of crack cocaine. Here, in our case, we have somebody present with a very small amount of fentanyl, a digital...
In the same bedroom? In the same apartment?
I don't think that there's evidence about what bedroom. It's the same apartment, but we know that in these two prior cases, he has a very small amount of fentanyl, a digital scale, and in one case, a calibration weight, and another case, a box of sandwich baggies. So in each prior case, he has indicia of distribution. In this case, there is none. And that's a huge distinction because what's
But
left
there was
is...
a scale in the other bedroom, wasn't there? A digital scale in that bedroom, another indicia of distribution?
in the sister's bedroom that was inaccessible to him behind a deadlocked door. I mean, this door was so securely fastened, ATF agents had to take it off its hinges in order to access it. And again, going back to cases like Rivera and Schmieder, they say we look to the items that are in those rooms to determine who has access to these places, who is exercising control. Can we establish constructive possession? We see here that the jury acquitted Mr. Clemente of every of the drugs in that room, both on the trafficking charge and possession with intent to distribute cocaine. So I think, again, we look at, can he access this room? It's clear that he couldn't on the facts presented at this trial.
Are you aware of any cases where this court or the SJC has addressed the improper use of a prior conviction to prove an element in the Commonwealth's case in chief?
Could you repeat the question?
Sure, it's a poorly phrased question. We don't have a lot of cases that involve prior convictions for the precise same conduct. Typically, that is not admitted at trial. Are you aware of any cases where we have held that the use of a prior conviction that involved the same conduct was inappropriate?
So I think my strongest cases on that would be Commonwealth v. Yates, Commonwealth v. Anderson, and Commonwealth v. Bruce Julius. And in those three cases, which are cited in my brief, the court is really focused on the fact that those prior convictions don't share those unique similarities that we see in Healthfant, Cater, and Sharp. It's not that kind of signature crime. And as a result, even though when you have a signature crime, you might be allowed to admit prior bad acts from 3 years earlier, that time limit really doesn't exist. I think Anderson specifically says it could be 15 minutes between the two acts, and it's too attenuated if they don't share those unique similarities. Somebody possessing a small amount of fentanyl in their bedroom is just not unique, particularly without the indicia of distribution that tied those other two cases together and proved his intent. So without that, what we have is the jury basically using propensity reasoning because they don't have those unique similarities. And that's what our courts caution again and again, because when it comes to intent, it looks an awful lot like propensity reasoning. We need to have those unique similarities. We need that close time frame to allow the evidence to be probative of his intent 3 years later. Here, it's not tying together.
Well, the time frame seems less important when there's more detail and more similarity, like Healthfont, which is obviously distinguishable from this case, but Healthfont was a 3-year separation in time.
Right, and that was, again, a basically signature crime. You have a doctor sexually assaulting his patients after drugging them with Valium. I mean, that's a very specific fact pattern. And so for the same reasons that the prior bad acts can't render the evidence sufficient, they also shouldn't have been admissible in the first place. And that's, again, because the only way they can be used is for propensity reasoning. And that's because they're not similar in time and they're not similar in their fact patterns. And as a result, there was no other compelling evidence of intent here. And they were convictions, as Your Honor said, for the exact same crime, which heightens the prejudice. The prosecutor's closing theme really emphasized he's been convicted of these crimes before, and therefore he must be intending to distribute the drugs this time. They admitted this evidence in 3 different methods, 2 of which the jury could have taken back with them to the deliberation room, including the docket sheets and the plea colloquy. That's an enormous amount of evidence on an element that the Commonwealth really had no other evidence to show.
Could I go back to the items found in bedroom 2?
Of course.
Would you agree there's a difference between the concept of control versus accessibility? So the jury could have found there's not enough evidence that he controlled the drugs that were found in the room and therefore acquitted him, but that the items, the scale and the other items, were still accessible to him.
I think had they been accessible, perhaps. I think that's totally reasonable. Here, they weren't accessible, right? They're behind a locked door. There's no key in the apartment.
Why can't they infer that, it's his sister's bedroom and that he, when she's home, would be able to access the items found in her room, especially where there is a piece of his mail in the room. I understand it was in a pile. And he also admitted that he does sell marijuana, right? So presumably he would use a scale for that purpose.
So I think that we know, right, that she was selling fentanyl. We know that she was selling marijuana based on the evidence found in her room.
We know that the sister was selling fentanyl?
All of the evidence of the indicia of
I don't know if we
distribution
know
is
that,
found
but,
in her room.
okay. But we don't know that she was selling.
Well, there's lots of evidence that's found in a bedroom that we know, based on the evidence, belongs to her, behind a deadbolt, right, that again, he can't access. There's no way for him to access to it. So I think it is quite speculative to say, well, he could have asked her for the key when there's no evidence put on by the Commonwealth that they had that type of relationship, that they shared that key, that he had access to the bedroom. You can imagine living in a family with the same mailing address, that one piece of mail slips into a pile of mail, but it's all her mail. So again, I don't think that there's a proper inference based on the great weight of the evidence here that he was accessing this room.
What if it was a common area that had a lock on it, like a basement door? You can't infer that he might have access to the basement if he lives there?
I can imagine a situation where, say, it's a storage locker where the folks in the house store all their stuff and there's, shared stuff in there. Here it's her room, right? It's her bedroom, her bed, her private things, her sanitary products, her passport. She has a lot of private items in there. And so it's, I think, again, clear from the evidence that she was sleeping there, she was staying there, and there's no evidence put on by the Commonwealth that he had any access. If there's no further questions on that issue, I'd like to quickly address next.
I wanted to just circle back to the significance of the jury's acquittal on the cocaine distribution. All of the cocaine being in the sister's room behind the locked door, and they say, okay, we don't believe he was intending to distribute that. I think it's fraught to infer too much from a jury verdict in any direction. Do you rely on that in any way, and do you have any authority to rely on that to support the inference that because the jury didn't believe that he had access to the cocaine, he also didn't have access to the other indicia of distribution?
I don't rely on that, and I think it's because, like you said, it can be quite fraught, but I think it shows, like all of the evidence that was put before the jury, that he didn't access that room. So I would like to, I know I'm running out of time, I'd like to quickly turn to nexus. There was no evidence in the search warrant affidavit supporting an inference that Mr. Clemente's Brockton home was associated with a firearm distribution conspiracy happening in New Hampshire, and that's because there was no evidence in the affidavit about his home other than the fact that he lived there, and we know that's not enough.
Hardest fact for you, I think, is the idea that he might have a drill in his apartment, that's the kind of thing that there's the case laws all over the place, but maybe that's the kind of thing that a person would keep in their home because maybe it's valuable, although Judge Davis said, what are you talking about? You can go to Home Depot and get them for $5. Right. What do you say to that?
I'd say we have one text from January 14th that has Mr. Clemente removing one serial number from one firearm. We know that's one instance. There's no evidence about where he is when he's doing that, what tool he's using, whether he uses it again. But we also know, based on that same affidavit, somebody else named Pancho is also taking serial numbers off of firearms as part of the same conspiracy. And they're texting about that on March 11th. The search warrant is executed April 16th. So whether these tools are traveling around as part of this conspiracy, we just don't have very much information we know from this.
Your time is up, but I have one additional question.
Of
At
course.
trial, some evidence of the gun conspiracy came into evidence. Is that true?
I don't believe so, Your Honor. I believe there was a short voir dire of one witness who was the one who wrote the search warrant affidavit, but that was not evidence before the jury.
So no evidence of the gun deals and the
I think they were very explicitly kept separate.
kept separate. Very good.
Thank you, Your Honor.
Check, see if there's anything further. Nothing further. Thank you very much, counsel.
Thank you.
We'll now hear from the Commonwealth.
Thank you. If it pleases the court, Arne Hansen for the Commonwealth, I would ask that you affirm the defendant's convictions. With respect to the nexus issue, there's substantial evidence that linked the defendant's home to his firearms trafficking. What we have here is we have substantial evidence that was derived from the accomplice's, Korea's cell phone, that illustrates that these two individuals used their cell phones to coordinate their firearms transactions, as well as trafficking. The defendant instructed Korea when and where to purchase firearms, which firearms to purchase, and then instructed her what to do with those firearms once they were purchased.
There's a lot of evidence that he was involved in the conspiracy or gun trafficking scheme. I agree with that. The cell phone evidence is strong evidence that he was involved in gun trafficking scheme. But I didn't see any evidence that it was linked to his home. Can you focus me on that from the record evidence?
Yes. So I think Commonwealth v. Perkins controls here. So Perkins was it was a large investigation into drug trafficking organization. And the SJC in Perkins upheld that you can execute a warrant on Perkins's home because we know, based on the evidence, that he used his cell phone to coordinate these drug transactions. We have the exact same situation here where the defendant, we know that he used his cell phone to coordinate the firearms trafficking organization and those transactions. So it's analogous there. And the court upheld, obviously there's evidence going to be on his phone because we know he used his phone to further these crimes.
I'm deeply troubled by that analysis. So I think we can agree that today, in 2025, everybody has a cell phone. Literally everybody has a cell phone. We can also, I think, agree that the Fourth Amendment gives special protection to a person's home. So if the inference, the train of inference, which I think you're relying on Perkins for, is this guy used his phone for the scheme, and it's reasonable to believe people keep their phones in their home, then I think the problem is that under the Fourth Amendment, the special protection of the home is eliminated. Where have I gone wrong in that line of reasoning?
I think that's fair. It's part of my argument. It's not my entire argument. There's also direct evidence that the firearms came to Massachusetts, where the defendant stated to Korea, hey, I sold this firearm on this date, I sold this firearm on that date. We know that some of the guns went to Fall River, and we know that one of the guns ended up in Hyde Park. The purpose of this type of conspiracy is to get guns easily from New Hampshire, where you don't need to you don't need a license to buy them, and bring them to Massachusetts, where it's much harder to acquire firearms. We know that the defendant defaced at least one serial number because the text messages relay that, and you would need a tool to do that, and he had some difficulty doing that. The case law, I think, is very clear on when you have items that are of continuing durability that aren't necessarily incriminating, like a tool that could be used to deface a firearm, it's reasonable to expect that those will remain in a person's home.
Here's my problem with that. So the defense cites a string of cases about drug distribution, and specifically the indicia of drug distribution, or what I'm interested in. So the digital scale. It seems to me the digital scale is kind of analogous to the drill. So in other words, in the line of drug cases that your sister cites, the basic gist of it is, if you're going to investigate somebody for drug dealing, you got to find evidence that the drug dealing paraphernalia are linked to the home before you can start going into the home. It seems to me that on this theory that the drill is the kind of thing you would keep at your home is just like the theory that the digital scale is the kind of thing that you would keep in your home. But the case law cited, which I don't think you address, seems to undermine that notion. In other words, we know this guy's a drug dealer. We can infer that he has a scale someplace, but we're not going to let you go into the home until we have evidence that that drug dealing is connected to the home, and having a scale is not enough. So how is it enough that maybe we can infer, and I'll accept, we can infer that he had a drill. How is that enough?
So we take the search warrant in its entirety, so that all these are bits and pieces that add up to the puzzle. We also have two messages. One that is very direct, where Correa buys a Ruger firearm on a date. She communicates that via text message that I bought this firearm. He tells her to bring it to, I think the quote is, go to mama's. We know that the defendant lives with his mother. It is reasonable to infer that the defendant is instructing Correa to bring that firearm to his mother's home where he lives. There's another message, again, some of the language used by the defendant is sometimes hard to follow. There's another message a couple of days after that where the defendant again instructs the Correa to bring 2 firearms to my big boy. Could be interpreted to mean him. Sometimes his language is difficult to follow, but it is a reasonable inference that you can draw. So we have on at least one occasion for certain, a second one possibly, that he's instructing her to bring the firearms to his home. Now, with respect to the sufficiency of the evidence argument, there's...
Actually, let's go to the prior conviction issue.
Yes.
Is Goldman your best case?
Goldman is a great case for the drug distribution and the modus operandi. So what we have here is 3 investigations into this defendant. All of them follow the same pattern.
I want you to answer my question. Is Goldman your best case?
Yes, as well as Helafont. So Helafont identifies the temporal issue.
But Helafont is really an MO signature case, right? Doctor takes women to, I think, to his home, or in any event, uses Valium and then sexually assaults them. How does this case remotely approach that type of signature or MO? My understanding of the evidence is essentially in the prior cases, he had a small amount of fentanyl in the apartment. He admitted to, in the prior case, to intending to distribute it. In this case, there's a small amount of fentanyl in his apartment, and we're using the prior conviction to demonstrate intent. So, I mean, tell me if my understanding is incorrect first.
No, I agree with Your Honor's assessment.
So how does that fit within Helafont?
It's a very specific modus operandi. So this case was different because there was a federal gun investigation that led to drugs that they didn't really expect to be there, I assume. What happened in the prior occasions is that there were search warrants for a narcotics investigation. He's the target of the investigation. Presumably they do control bias with CIs. They establish a sufficient nexus showing him going back and forth from his home after these drug transactions. So there's on two separate occasions they've established, and he pled guilty to the fact that he distributed drugs out of his home, or at least used it as a home base. It's the exact same situation here.
That he distributed or that he intended to distribute?
That he intended to distribute. That he used his home as a base of operations for his drug distribution, I should say. It's the exact same thing here. They execute the search warrant, and they find it's in a separate room that is, I think there's a clear distinction here. Defense counsel is harping on the fact that the defendant didn't have access to it. What the evidence really suggests that the officers executing the search warrant didn't have access to it because they didn't have a key and they had to take the door off. There's nothing to suggest that the defendant didn't have a key and didn't voluntarily hand it over to the Commonwealth when they executed the search warrant. Now, it's interesting as well because he's linked to that room by several pieces of evidence. He admits that he's a marijuana dealer. And inside that room, they find a ledger. And the expert...
Sorry, which room? This is the sister's room?
Correct.
Yeah.
They find a ledger, and that ledger details different strains of marijuana being sold to different people. So that's evidence that links him to that room because he says, I'm this marijuana dealer and there's a marijuana ledger in that room. There's also mail in his room. In the sister's room. His mail is also found in the sister's room, suggesting that he did in fact have access to it. He further admits that because he's a marijuana dealer, the only place they find a digital scale and glassine plastic bags, which are used to sell drugs on the street, is the sister's room. So how is he going to sell marijuana without access to these items?
But all of this seems to go to sufficiency.
Correct.
So let's go back to the prior conviction issue. I'm just not aware of any case like this where in the Commonwealth's case in chief, it admits evidence of a prior conviction that a defendant admitted to intending to sell drugs to prove, in this case, that therefore he must intend here to sell drugs. That strikes me as propensity evidence. And I'm having difficulty finding a case that supports the Commonwealth's view here.
Yeah, but as I stated earlier, Goldman is the best case on point with respect to drug distribution. My argument with Halifant goes more to it's the exact same modus operandi. They find evidence of distribution on each of the 3 times that they execute the search warrants. He's using his apartment as a base of operations for his drug distribution. It's a completely different fact set than Halifant, but it's the same modus operandi. It's a consistent modus operandi.
So the MO is specifically what? Tell me with as much particularity as you can.
That he uses his home to distribute narcotics as evidenced by the fact that he has digital scale, weights, sometimes narcotics, other paraphernalia associated with distribution. But beyond...
If we agree with the defendant that the prior conviction should not have come in, are you making any argument that it was not prejudicial?
Yes, well, the court gave a contemporaneous instruction when that evidence was introduced, as well as an instruction during the final charge. Even taking those aside, there's substantial evidence of indicia of distribution, as we discussed previously. Some of it is found in the sister's room, and there's no reason that the jury couldn't have considered that evidence. And we don't know why they found him guilty of the lesser included but didn't attribute the cocaine. And that's just something that we're never going to know, because outside of showing that the jury was prejudiced or by some type of racial motive to find the defendant guilty or was influenced by outside factors, we can't really impeach their verdict or question why they came to that verdict.
Well, it occurs to me that maybe the jury verdict acquitting him of the cocaine, at the very least, shows us that it was a close case and the jury was struggling. And so on this question, Judge Shin's question of, is this harmless error, the admission of these prior convictions, establishing harmless error is going to be harder if it's a close case. Do you agree with that?
I think that's a fair assessment of the case, but really what we're dealing with is the Lattimore standard and whether or not the Commonwealth had provided sufficient evidence prior to the case getting to the jury. The judge is the gatekeeper here, and he throws out cases that shouldn't go before the jury.
No, sorry, I may be wrong, but I thought we were talking about whether there's an argument that if it was error to admit the prior convictions on the question of intent, that is harmless error.
Oh, I'm sorry, I misunderstood.
Yeah. So, and do you agree with me that the jury verdict support an inference that the jury thought this was a close case, and that any piece of evidence, such as the prior convictions, might make a difference? That it's hard to make an inference that this wouldn't have made a difference?
I think that's a reasonable assessment of the situation. But again, we're just never going to know what the jury was actually thinking and what underpinned the conviction, and we can't go back and reevaluate that, or we can't evaluate it at all.
I'm wondering also how much the limiting instruction would have mitigated any error when the instruction seems to incorporate what might be the error. In other words, the instruction says you can only consider this evidence as bearing on defendant's intent, but if that's in fact propensity, then the instruction doesn't mitigate the error, right?
Just that I don't disagree that that's a reasonable assessment of the situation.
Okay.
Final question from me. Am I correct that the judge allowed the Commonwealth to introduce testimony with respect to the prior conviction? Number one, testimony from an officer who I think was either present or was aware of the circumstances from the prior case. Two, the tape or transcript of the plea colloquy, and I think there was something else, oh, and the docket from the prior conviction. Were all three admitted in this case?
Yes, and my understanding with these types of cases is when you have, essentially what they did was prove it like a subsequent offense or like an ACC trial. That's how you get prior convictions into the record in those types of cases, and that's what happened here.
All three are needed? Really? It's interesting.
In my experience, it's a booking officer who is familiar with the facts of the case and can place the defendant at the scene or at the crime scene saying, this is the person that I arrested, this is the same person. And then you need
Either a certified copy of conviction or
copy of the
in the
conviction.
docket, right?
As well as often there's additional evidence that from the RMV that corroborates the person's identity to establish that they're one and the same. You can get that in through the booking officer as well, saying, on this date, this person told me my date of birth and social security is this, and then on this date, this person told me the exact same thing.
Would you agree that, as a general rule, introducing evidence of a prior conviction may be more prejudicial than just evidence of prior bad acts without the imprimatur of the conviction itself?
Yes, that's a reasonable interpretation because it's, stamped by the court.
Okay. I see no further questions. I'd like to thank counsel, well briefed, well argued, and we'll take the case under advisement. The case is submitted.
Thank you.
Next case, docket 24P312, Commonwealth v. Tulien or Tuyen. And again, if I mispronounce the name, please correct me. Good morning, counsel.
Good morning, Your Honor. One moment, thank you. May it please the Court, Suzanne Renaud for COL TULIEN. Your Honors, I'd like to be able, there are a lot of arguments here. I'd like to be able to start with the felonies if I can. And just off the bat, I'd like to start with witness intimidation. Now, there is some language in Bellard that I just wanted to bring to your attention where it says that if the fact finder wasn't presented with a particular theory, then that theory is not ripe for being considered on appeal. Now, I know Bellard was a bench trial, so there were no jury instructions, and that section of Bellard cites to Pfeiffer. But I just wanted to put that out for this court's consideration because the citations provided by the Commonwealth regarding the intimidation theory of witness intimidation actually were dealing with the stalking charge and the other witness intimidation charge, both of which he was acquitted of.
Could I push back on that a little bit? So I'm looking at the closing argument, the
Yes,
Commonwealth's closing argument, and it goes through the events of March 18th, and then the prosecutor says that is intimidation, that is harassment, which is exactly what the witness intimidation statute addresses. So it seems to me this theory that it was intimidation, harassment, as well as a bribe, was squarely presented.
Well, Your Honor, I would just say that when we're talking specifically about what was happening on August 20th, at that point, he said, he couched it in terms of basically the thing that Mr. Tulien was trying to exchange. So at the end of the day, I don't think this point is the most salient point, but I would say that my reading of his closing argument definitely limited it, this particular charge from August 20th to the bribery charge. Notwithstanding that, when we are talking about what is intimidation or harassment, those kinds of things as animating the drop the charges claim that he apparently made, this is not a case like Gardner or even the facts in Bellard, where you have a long-standing domestic violence relationship with years of domination by one party over the other. We've all seen those kinds of cases. We can see it in the fact patterns of these two cases. That is what is being referred to when they're talking about this history of intimidation. What we have in contrast here is a very short history that Commonwealth put in, one event from February that was put in for a limited purpose, then we have the events of March 18th, and then we have 3 days of pretty ineffectual text messages that even the Commonwealth admits are sometimes conciliatory. What we don't have is that type of relationship established on the facts where the witnesses said, I was in fear of him. I was in fear of him when we were living together. I kept taking away my, I kept recanting because of this person, which is what happened in Gardner. What we have here are two people who didn't even live together, and the wife in this relationship had another boyfriend. It is an entirely different set of facts that the jury was presented with.
You say that the February incident was not admitted for its substance.
It was not. It was admitted as a prior bad act.
Right, but it's still admitted for its substance, just not as evidence of character or propensity, but you still consider it for its substance. I mean, it's not a hearsay, right?
You could so the jury obviously had to first credit that it was true, and I mean, we're going to make an assumption that that's what they did, but then the judge put a limiting instruction of the purposes for which it could be used at trial, and one was to show, I'm sorry.
His state of mind. And
His state of mind.
the discord between the parties.
And the discord between the
So
parties.
that's relevant, right, in a Gardner sense?
So that would be relevant in a Gardner sense, and not how the Commonwealth phrased it, I believe, in their brief, but it would be relevant in a Gardner sense. But again, you have one event and not a long-term history of this kind of domineering relationship that 6 months later we're asking the jury to say that this was such an overwhelming relationship that she couldn't help but feel intimidated, and that this was his specific intent to use this as another data point in which to intimidate her or scare her into doing the thing that he told her to do. That is what Gardner is suggesting. That's even somewhat what the facts of Bellard might have suggested. That is not what this case is suggesting, and I don't think that's a fair reading of the history of this relationship that was presented before these jurors, because you have that one incident where clearly, he's alleged, in accepting that it's true, that he smashed her windshield, and then obviously what happened on March 18th. But he didn't come in her physical vicinity after that. He, 3 days from June to August, texted her, I want my money, please give me my money, I'll swear at you until you give me my money. This is one small, ineffective, but also sometimes conciliatory, as I mentioned, issue that he is focusing on when in relation to his conversations with her, and that is all that is before the jury, aside from those two other events.
There are many texts, right? And some of them said, "Tell the police to let me out."
That was the subject of the witness intimidation charge for which he was acquitted. That March 18th witness intimidation, tell the police to let me out, tell the police to let me out.
What do we do with we can't. We can still consider that, right, in terms of whether there is enough evidence to support another charge.
I suppose you could use it as part of the history to establish that he was. I think this is getting really troubling, Your Honor, because that specific event was, the jury was told that was an intimidation, that he had this intimidating relationship with her, and then when he said, tell the police to let me out, that's witness intimidation. The jury didn't accept that. Now, the idea that on March 18th, he was nonetheless saying, tell the police to let me out, tell them to let me out, tell them to let me out, I suppose that's a fourth day, but that still does not indicate that he did indeed have this domineering relationship over her. It shows that he was begging her to let him out, or to get the charges dropped. That's all it shows. That is not the same thing as saying that I am the person who's in charge of you and that I am overwhelming you with the dominance that I'm exhibiting and the violence that is inherent to the relationship, which is exactly what Gardner is trying to get at.
So the witness intimidation count for which he was convicted was the $2,900 COVID payment, correct?
Correct, Your Honor.
So you state in your brief that the offer to provide tax relief could not be a gift or other thing of value offered to influence the victim's behavior because the defendant did not have the money in hand and thus lacked ability to give that gift. That's what you state in your
That
brief.
is correct.
So here's a hypothetical. A criminal defendant has a case pending, and that defendant contacts the victim and says, look, don't testify, I'll give you $1 million.
Well,
It seems to me that, under your theory, the Commonwealth would have to prove that the defendant had access to that $1 million in order to prove intimidation of a witness, and that's not my reading of the statute or our case law interpreting it.
so I think that the difference between your hypothetical and what was going on here, there's two differences. One, I should just point out, first of all, it's their joint money, which means it actually is money that belongs to Mrs. Julian. She doesn't have it illegally. She has it in her bank account. It belongs to them, I suppose, but to her, and she's not doing anything wrong by holding it. The difference with the hypothetical you propose is that the defendant might get access to that $1 million. You and I don't know whether or not he actually has the ability to, do something with Bitcoin and get that $1 million. The difference here is that we know factually that he doesn't have this $2,900. It is not something he has. She has it. And we're speaking specifically here, not of any general $2,900. We're talking about the COVID money from the IRS that the IRS controls, that the IRS gives to the filing taxpayer, who was Mrs. Tulen.
But I'm sorry to interrupt, but does any of that matter? In other words, is your contention that in that text at 8:43 in the morning, or at night, I can't remember.
It's
in the
morning.
morning. He is lying and that she knows he's lying? Isn't it? In other words, he's saying, look, if you drop this, I'll help you get $2,900 or my half of the $2,900. Isn't the important question that he is not lying and that everybody knows he's not lying? He actually thinks he's conveying, I will help you get some money.
Your Honor, I'm going to just focus you on contract theory. That would not be good consideration. If it is imaginary, if it is illusory, if it is illegal, none of those things can count as good consideration. You can't have a quid that's made out of something that doesn't actually exist. He doesn't have the $2,900. He has no ability to get the government to give an additional $2,900. Any proposal to do that is basically trying to commit some sort of fraud.
We're not in contract law. This is not a breach of contract claim. This is a criminal case. And the question is whether he has the intent to bribe her. And I think that's the real question. Why does this text not establish an intent to bribe her?
Because the actual bribe has to be real. That's what Bellard says. Because the defendant in Bellard was trying to bribe the woman by saying, I'll get DCF to back off. But if he doesn't have any control over how DCF acts, then it's not a real bribe. That's what Bellard says. And so very clearly here, since the law has come out from Bellard, that puts a limiting principle on whether or not this indeed could be considered a bribe.
What's your best case that's precedent, not a Rule 23?
I'm sorry, that's precedent on?
What's your best
Bellard
case?
is not ruled, it's a SJC case, Your Honor.
So, okay, you cite in
I cited it in the reply brief because it
prior
was,
to the SJC taking it. Got it.
yes, Your Honor. And so in the reply brief, I
In
certainly-
Ballard, the problem was the defendant there had no conceivable ability to deliver on the promise, right?
that's-
I mean, terminating a DCF investigation. Here, why isn't at least conceivable he could deliver on the $2,900?
Because the law, the PUA law that he references, allowed $2,900 per taxpayer. It had already been paid out, which is why he was asking for it, and there was no second round of money. There was no other money that he could produce. I mean, but also just as a side note, he doesn't have control over when somebody files for divorce, but he can't control that second output
Right,
of
even
money.
even if we were to accept that, I thought the Commonwealth's theory was that he was saying in this text that if you drop the charges, then I'm not going to come after you for the $2,900 you already have. So that's certainly within his ability
So,
to do,
first of
right?
all, that's another problem. I think that the Commonwealth's reading of this is very not supported by what the text actually says.
Yeah, I mean, the
But
text is difficult
but-
to understand.
but I think that
if,
the
if
other-
you accept their reading of it, then
But I
that's
don't-
something he could deliver on, correct?
The thing about it is, Your Honor, this is again a legal situation. I'm not going to come after you for the $28,900 that he doesn't actually have a legal right to. It's joint money that she received legitimately.
Right, but the problem I'm having with you, and I'm sorry to interrupt, but is that I don't think it matters what is truth, what the tax law entitles him to. I think it matters what he thinks in his mind, whether he's right or wrong.
I disagree with that reading. I think,
so that's- but-
and I
okay,
think that that's where Bellard kind of clarified.
You rely on this principle that I think you're articulating, and correct me if I'm wrong, that it doesn't matter what he thinks. It has to be objectively true.
I think
That's your argument?
That is my argument. I think that that's, at the end of the day, the argument. I only have a small amount of time. If I may just mention the assault and battery. Assault and battery with a dangerous weapon always involves some kind of object. When you have an object hitting an object, it still has to end up hitting the person. And I think that's what comes out of Poro. What happened in this case, Your Honors, is that we had a crumple zone. And that is important because when you have a dangerous weapon, the idea is it's going to increase the amount of force. It's going to amplify the force. But when you have a car that takes on all that force, in other words, Mr. Tulien's car, the one that crumpled, and her car had very little damage to it. You cannot automatically make an assumption, like when a car is T-boned at 70 miles an hour, that the person inside the car is touched.
If there was evidence that his car struck her car, and as a result, she hit the steering wheel hard, that would be sufficient, correct?
Oh, that would certainly be sufficient. I think even if she said, I was jostled in my seat and my seatbelt tightened on me, that means her car is touching her.
Your argument is there's no such evidence here. Let me ask you a question. Is it a reasonable inference to draw here circumstantially?
So in other
Say no, and so tell me why not.
Because his car took all the force, because you can hear her screaming, her voice doesn't hitch. And when asked after you got hit, what did you do? She said, I kept driving. There is absolutely nothing on this record that really suggests that the force got passed along. And I think that this is one of those few cases where it's very speculative to think that that could be concluded based on the facts that are presented. And I would,
See if there are any further questions.
thank you. I'll rest on my brief. Thank you, Your Honor.
Thank you very much. And Commonwealth.
Good morning. May it please the court, ADA Megan Monahan on behalf of the Commonwealth. Seated with me on council table is the trial prosecutor, ADA Sean Riley. This is a case of domestic violence. In this case, the defendant, shown to be erratic, aggressive, and volatile, exerted power, control, and authority over the victim, his estranged wife. And the defendant's actions, his deliberate choices to seek out and harm this victim, beginning on March 18, 2020, and continuing through August 22, 2020, culminated in his convictions of assault and battery of a dangerous weapon, witness intimidation, violation of Chapter 209 order, reckless operation of a vehicle, and a threat to commit a crime.
So let's start with the ABDW.
Yes.
Where is the evidence that the victim was either injured or suffered harm or suffered an offensive touching? Is it just the screaming, or what evidence do we have in the record?
No, Your Honor, I would say that there is, considering the entire scenario, there is the evidence of touching. The defendant pulls up next to the victim in the middle of the night and said, "Today is the last day for me to kill you." That's his motive, his intent in there of a serious-ish thing. He then begins an 18-minute, 50 to 60 mile per hour chase through several towns. As he's pursuing the victim, he's using his vehicle as a battering ram. And I would suggest, Your Honor, that the crumpled hood of the defendant's car, which the Commonwealth included as supplemental appendix, pages 3 to 5, shows the amount of force that was hitting into the victim's vehicle. This wasn't a minor fender bender, as the defendant testified to. This isn't a light touching. This was a 50 to 60 per mile crash at least 3 occasions with a crumpled hood.
Yeah, but just basic physics, like high school physics, if they're both going about the same speed, we keep saying 50 miles an hour. Can we infer that the difference in the speeds, the delta of the speeds, is pretty small? that somebody going 51 miles per hour hitting somebody 50 miles per hour is not going to have much force. And so, answer that first.
Okay, so I will take back to the jurors can have the common sense and experience, and that all of us have probably at one time and another tapped a bumper of our car. We've all kind of gone into I'll just imagine a parkway, bumper to bumper, you're on the brake, someone taps you. Less than 5 miles per hour, you feel that. That is the common experience. Now we're talking about, even in this differential, of say she's going 50 miles per hour and he's going 55, and every time, she testifies that every time he hit my car, I screamed, I yelled, I was crying, and we hear it in that harrowing 911 call. I would suggest that this isn't some mathematics, physics, I understand the point, but no matter how much that speed was, that car hit it at force because that hood was crumpled.
So the evidence is the speed of the vehicle, the crumpled hood, and the screaming.
The victim screaming.
Is there anything else?
Let's see. He hit my car, he hurt my car. I would suggest that when she's saying that, how did she know? Again, the jurors can consider she's driving that vehicle.
I had a question about the damage to her car. I looked at the photographs that were introduced. I couldn't make heads. It looked to me, and please correct me or direct me better to the best photograph in the record, that her car got anything more than a scratch. And where I'm going is, I saw the photos of his car with the crumpled hood, but my inference, I was struggling to understand how that impact on his car could cause nothing but more than a scratch on her car. And therefore the inference is, it's unreasonable to infer that crumpling occurred in hitting the rear end of her car, unless I have a picture that helps me understand that.
I understand, and I'm going to point you actually to the testimony of, I believe it was Trooper or Sergeant Kevin Murray, who looked at the vehicle. The photos are not great, but what he said is that when he testified, the bumper was separated, but most of the damage was to the undercarriage with the muffler pushed up and back. And yet it makes sense when you look at the two vehicles. You have a high SUV and a low Acura, and it is hitting at a point where it's hitting the undercarriage. And so, Your Honor, although the pictures, I would say, I agree with you, they don't do it justice. It's the testimony about the muffler and thinking of the undercarriage damage that was there.
So what was the touching precisely then? What could the jury infer was the touching?
I would suggest that the defendant's vehicle is the dangerous weapon, pushing the force, and that the victim feeling that can be inferred through all of this evidence such that
it was just feeling the impact of the car hitting the other car is enough for a touching.
I would suggest with the slight touch under an intentional theory, yes. And I'm not going under an extension of the vehicle. I'm going with the force, the touching, that necessarily.
You're not relying on, for instance, her seatbelt tightening or anything like that. You're saying just that feeling the impact is enough for it to be a touching.
Yes, there was no evidence of testimony that she was jostled, or that, let's call that would be the best evidence, and that's not in this case where we didn't have testimony that she was jostled, seatbelt, but that's not necessary where it's however slight that touch is. And so that force, that impact, there's a reasonable inference that she felt that and in some way could feel it and had such an impact that she was screaming. And she knew, because she's driving that vehicle, he hit my car. How did she know? She felt it.
You cited a bunch of cases, I think, on roughly similar fact patterns. Person A in car hits person B in car and held assault and battery. Maybe dangerous weapon. Can you give me your best case? Well, A, am I remembering that correctly? B, can you give me your best case?
Yes, so the two cases dealing with this were Burno and Porro, P-O-R-R-O. Now, I would suggest, Your Honors, that Burno, I believe the Commonwealth's brief cites the SJC case, but if you go to the appellate case that actually provides the fact pattern, and in that fact pattern, the two officers that were in the car that was struck, there was one was injured on the wrist, the other there was no injury, there was no discussion or testimony of feeling it or touching, but the Supreme Judicial Court affirmed it and said that if that evidence is presented again to the jury, because I think there was an error on the instructions, that would be sufficient. And so I think Burno, thinking of the fact pattern that's presented in the appeals court decision, that is our best case.
So you thought the appeals court did a better job than the SJC? Is that what you're saying, in describing it?
Well, yes. Or at least it was more of a bigger issue in the appeals court, such that. If there's no further questions on the assault and battery, dangerous weapon, I can move to the witness intimidation, or?
I'm more interested in the threats.
Okay.
So there's obviously case law that's changing the world of threats, the Supreme Court case and the SJC case. Do you think that that is relevant to this? I mean, I think we're all talking about the alleged threat on the night of the chase, saying this is the quote. If you can give me the quote, I don't want to get it wrong.
I will flip back to it for you. Milnine said, "Today is the last day for me to kill you."
Okay, right. So we all agree that that's what the jury had to find was the threat. And how does the new case law impact the viability of that?
The jury was not instructed on the new element, which is the subjective intent of the defendant. So that is where we have to be looking at whether or not the evidence or there was an eluctable inference that the defendant consciously disregarded a substantial, unjustifiable risk that his words would be considered a threat of violence toward the victim. So that is where the position of this case, pending on appeal, between Counterman v. Colorado and then Commonwealth v. Cruz, which Commonwealth submitted a 16L letter. So I agree that that is the posture we are in, that we have to be looking to affirm the conviction at appeal. It would be an eluctable inference. Now, in accordance with Commonwealth v. Cruz, if this court found that the evidence was sufficient under Lattimore, but not an ineluctable inference, it would be remanded for a retrial, and that's what Commonwealth v. Cruz held.
Well, Cruz doesn't say anything about whether it was an ineluctable inference. It just says we vacate the conviction.
No, and I looked at the parties' briefing on that, and that issue was not raised. Both the defense and the Commonwealth raised it here, that ineluctable inference became from the
but what do we do about the
case?
fact that our case is in the same posture as Cruz, right?
Yes.
The threat in Cruz was pretty explicit as well. I'm going to punch you in your face, right? And they vacated the conviction.
And again, Your Honors, I think there's I would suggest that when I looked at the briefing and I looked at the issues, ineluctable inference was not raised. There are other cases in a similar posture, I would say Guardado and Desierto, where there is this change in law. The court has looked at ineluctable inference where the parties have raised it. So that would be my suggestion. But again, if the court is following by Commonwealth v. Cruz, then
Are
it
we
would be
not in
remanded for
harmless
retrial.
error territory here under Bookman?
For harmless error for the piece we're discussing with the instruction, yes.
We're in harmless error, right? Not ineluctable inference. Do we treat it as a preserved issue?
Yes, where it's a new element here, I would say it's the harmless error.
Yeah.
And then is whether that error is harmless is whether we can make an ineluctable inference that he had the subjective intent. And so the error would not be harmless if this court found ineluctable inference.
Okay. And Cruz, you're saying, well, what do you think Cruz is saying?
I am with that. Cruz is that the issue wasn't squarely presented and it wasn't argued.
They just didn't address it.
It wasn't addressed.
So it's not binding on us on that aspect.
No, I would suggest that that's not binding. It just provided the pathway that if you found we did not meet ineluctable inference, but it was sufficient under Lattimore, the posture would be it would be remanded for retrial. There would be no double jeopardy. I would suggest that here, why it's ineluctable inference are two. By the jury finding the defendant guilty of assault and battery with dangerous weapon, they found beyond a reasonable doubt that he used a weapon to touch the victim. The defendant was driving on the wrong side of the road after midnight. He pulls up beside her and says, "Today is the last day for me to kill you." For approximately 18 minutes, he then chases her. It's the defendant's actions. So he didn't just send a text message like in Cruz. It's the defendant's actions immediately after the threat that pushes this over the line, and especially where the jury found him guilty of assault and battery with a dangerous weapon, that just bolsters the intent for the threat to commit a crime. Let's see. I did want to just make, if there's no further questions or if there's no other issues that this court would like to, I just want to make a housekeeping, was that in preparing for my brief on the 209A violations, I just wanted to make it very clear for the argument portion in drafting multiple drafts for this brief, I neglected to include the March 18, 2020 conviction in my argument itself. It's in the statement of the case and the statement of facts. I just want to be clear that my argument applies to all of the convictions that they should be affirmed on the 209A violations.
Should we infer from the acquittal on count 6 that the jury found he didn't have knowledge of the 209A until March 18th?
I would suggest that in this case where there were so many indictments and differences in acquittals and verdicts that we can't make any inferences of what element the jury did and did not find. When I took a step back and I looked at the acquittals versus the verdicts, I'm just trying to be very careful with the impounded information, that the jury was incredibly deliberate in that it appeared that where there was overlapping conduct for convictions, they acquitted on one and found it guilty on another. And so it looked more to me like a leniency and compromise, and that we can't infer the element of knowledge. I will say one thing, though, that even if this court did find that he did not know until March 18, 2020, the actual terms, the February phone calls and voicemails are still really important, at least to the sense of when we're discussing whether or not it's void or the collateral attack, because if he received those voicemails, I would suggest that the evidence shows that he did, and that he called back the Randolph main line, that is a reasonable opportunity for him to further inquire about the order and its terms, and that goes to that question of the collateral attack. So he didn't actually have to know, and I'm sorry.
He could file a motion to vacate. Your point is,
Yes.
he had the ability to file a motion to vacate, but it's good enough that he had an opportunity to ask the cops when he called the station, whether or not he actually called the cops, or whether he actually asked the question. That's your argument.
That is for the reasonable opportunity in the collateral attack, which is how I can distinguish it from the elements of the charge for the March 18, 2020 conviction, in that the jury had to find he knew the actual terms. And so that I'm trying to get at is the discrepancy or difference where the finding of not guilty on one conviction isn't inconsistent with he received phone calls and a reasonable opportunity to inquire about the order. If there are no further questions, the Commonwealth will rest on its brief.
Seeing no further questions, thank you, counsel. Record will reflect both parties have been very well represented and the case is submitted. We're going to take a brief recess.
All rise.
Court is now in session. Please be seated.
Calling our next case on the list, docket 24P679, JK Scanlan Company LLC versus Edward Bartlett Jr. and others. We'll hear for counsel for the appellant. Good morning.
Good morning, Your Honors, and may it please the Court. Emily Musgrave on behalf of the Trust as appellant, and with me is my colleague Mitchell Clough. In G4S, the SJC held that contractors seeking to recover for a breach of a construction contract must first show that they completely and strictly performed all of the terms in the contract that relate to design and construction. The contract here required the general contractor, Scanlan, to supervise the construction. But the jury found that Scanlan was, quote, negligent in its supervision of the renovation project, end quote. That finding should have cover on its breach. $1.7 million on Scanlan's breach of contract claim. In post-trial motions, the Trust asked the trial court to correct the jury's legal error. The trial court devoted a single sentence to this issue, summarily concluding G4S does not apply here because Scanlan's quote-unquote failure to supervise does not relate, quote, to any contract provisions involving construction of the project. In other words, according to the trial court, negligent supervision of construction does not relate to construction.
So I have a preliminary question. Did you seek direct appellate review at the SJC in this case?
We did not, Your Honor.
My next question is this. Part of your argument, it seems to me, is that Scanlan's supervisory role relates to design and construction as a matter of law. The judge erred in failing to make that determination as a matter of law and should not have submitted that to the jury. Is that a fair summary?
I think that's a partial summary, Your Honor. The judge erred in failing to make that determination, and no reasonable jury, if presented with that conclusion, could have reached the outcome this jury did.
Prior to this case being sent to the jury, and I know you weren't trial counsel, but did trial counsel say, hey, Judge, wait a minute, this is a question of law for you to decide, don't submit that to the jury? Did that ever happen in this case?
It did not, Your Honor, and that's because this was the first case post-G4S that we're aware of and that's present in the parties' briefs to have gone to a jury trial. And this verdict provides a unique insight into the problem with applying G4S because we have these two competing inconsistent verdicts.
I appreciate that. But how can we say the judge erred when no one asked the judge to consider this issue as a matter of law in the first place?
The appeal here, Your Honor, is from the judgment, which includes the post-trial motion. So the judge had an opportunity to correct the jury's verdict and didn't do so. The judge had an opportunity to correctly apply G4S and didn't do so. And that situates this case in line with other cases in which this court has reversed in similar circumstances.
But just to be clear, the judge wasn't asked in the first instance to make a determination as a matter of law, correct?
Correct.
And the judge's jury instruction was not objected to by trial counsel.
Also correct, Your Honor. And again, that's because this is really the first case where this issue presents itself. And but for the framing of the jury verdict in the way that it was framed here, I'm not sure we would have seen it, which isn't to say that it doesn't exist and isn't to say that it doesn't exist in the thousands of other construction law cases that are going to trial. It's just that because the verdict form here had both the breach of contract claim and the negligent supervision claim, and that they were broken out in these different ways.
Even without the jury verdict, you're making the argument that as a matter of law, Scanlan's supervision of the construction is indeed a question of law. That should be something that you would know regardless of whether or not that was put to the jury, right?
Yes and no, Your Honor. In the first instance, it is a question of law, the question being when the SJC decided G4S, which provisions of a construction contract relate to design and construction and which do not. What became apparent in this case is that that can't be submitted to a jury because clearly the jury erred in this regard and the judge didn't correct it.
Well, is there anywhere in this record that you can point to where trial counsel alerted either the judge or the jury that this supervision clause, that your client was relying on this supervision clause in defense to the breach of contract claim. It was brought as a negligence claim, but I didn't see anywhere where anybody told the judge or the jury, hey, sorry, I forgot the name, Scanlan can't recover on its breach of contract claim because it materially breached the supervision clause.
The supervision clause was first referenced in the trust counterclaim. That's paragraph 14 at Record Appendix, excuse me, volume 190. After that, it was in the trust's proposed jury instructions. They sought a G4S instruction, and it came up again in a pre-charge colloquy. The jury
The
was then-
supervision clause was not in the G4S instruction.
No, the supervision clause itself was not.
That's what I'm asking. So it's an affirmative defense, right?
It was a
So-
counterclaim here.
What was a counterclaim?
There was a negligence counterclaim.
Okay, I'm talking about, there's a breach of contract claim brought by Scanlan. It's an affirmative defense to say that they can't recover on their contract claim because they themselves materially breached the contract. It seems to me then, at some point, you have to identify what that material breach is for the fact finder, or if it's a question of law, for the judge. But they can't be expected to go through a 72-page contract and look for material breaches on their own, right? So I don't see anywhere in this entire record where that particular clause was identified as the defense to Scanlan's breach of contract claim.
I agree, Your Honor. I think it's an inference from the G4S instruction that the trust repeatedly requested, and the fact that it appears in the trust counterclaim that negligence and supervision itself were a theme throughout the trial, and that I assume trial counsel was of the view that providing the G4S instruction would be sufficient. It really
G4S
wasn't.
instruction was general.
Yes.
Right? It didn't identify any particular clauses as a material breach. Would you agree with that?
The G4S instruction is given to the jury, yes.
Yeah, okay. All right, well, that's where I'm having the most basic problem, is that, you can't expect either a judge or a jury to go through a 72-page contract and identify the clauses that are in question.
I think that's exactly our point, Your Honor, which is that what this case shows us is going forward, there needs to be a better process for implementing the SJC's decision in G4S, because what we see from this verdict is this process didn't work. Now, G4S itself was on appeal from summary judgment. The only other case we're aware of is the Ken case decided by this court, but that was a bench trial. So what we see here is that there needs to be some sort of pretrial process for determining which of the provisions in the construction contract are G4S provisions and which are not. And
Well, hold on. There was an opportunity after the jury came back with its verdict to address this. And in your reply brief at 10, you say, recharging the jury in these circumstances would have led to only one result, one highly prejudicial to the trust. That sounds to me like a tactical decision, that your trial lawyer said, oh, I don't want to touch that with this jury. They've already whacked my client. I don't want to bring this up. But that's waiver. In other words, it could have been fixed. You keep saying, this is impossible to fix. That's the moment where one moment, there are multiple moments, that's one moment where it could have been fixed. And it sounds like you're saying your trial counsel made a decision not to fix it. Not that he didn't know about it, or it was too complicated, or he hadn't foreseen it, but he didn't want to do it.
that's not what we're saying, Your Honor.
Okay?
First, had trial counsel contemporaneously objected, the point of a contemporaneous objection is to ensure some sort of contemporaneous remedy, that the issue could be dealt with before the jury were discharged. That couldn't have happened here. First of all, we know from the post-trial briefing and the trial court's decision on the post-trial briefing that the trial court would in any event have been of the view that this was not a G4S provision. So had the trust timely objected at that point in time, that's the first hurdle. The second point on the prejudice is that in order to then re-instruct the jury, and I think this goes to Your Honor's question, the jury would have then had to have been completely re-instructed on G4S, on how it applies to a supervision clause. They would have then had to determine whether that standard applies to the supervision clause, which again we submit is a question of law and not of fact. They would have then had to determine whether Scanlan completely and strictly performed that supervision clause, and if so, then did the trust breach the contract. That's a lot of ifs. that a jury at the end of trial would have to go back and reconsider. The prejudice point is that the verdicts are inconsistent, but one of them carries a very high damages number, and the other one doesn't. So there was reason to be concerned that even if a jury were able to be entirely re-instructed and redeliberate, they may be entrenched on the verdict as to which they'd already awarded damages.
Okay, well, I still don't, I'm not sure I follow that as something other than a tactical decision. But I don't understand the substance. Moving past waiver, I don't, on this, your repeated statement and argument that these verdicts are obviously inconsistent. The essence of it seems to me to be materiality. Do you agree that the three torts of negligence that were given are the heat in their home, the water dripping down onto the floor, and the elevator shaft being left open? Have I left anything out?
Those were, in my view, the greatest hits.
Okay.
Those were not the three
fine.
only.
The greatest hits, good way to put it, right? So that's not maybe all of it. In every one of those instances, the contractor immediately, according to my understanding of the record, remedied the situation. And so there was no damage to the property, much less any material effect on the design and construction of the project. To me, that is the essence of the G4S lesson for us, that we don't give a per se rule. It sounds like you're asking, this is obviously in conflict, we're asking for a per se rule that if you do anything wrong, even if you fix it, you then are barred from collecting in contract if the plaintiff, if the owner does what the owner here did, walks away and leaving you $1 million bill. Where am I wrong there?
A couple points on that. First, Your Honor is correct that G4S articulates a strict standard, and it's intentional. The SJC had the option to forego that standard and elected not to. And G4S is both about safety and about design and construction. You look at some of the examples that they give, notably in their footnote 16, they talk about highway guardrails. They even talk about inferior plaster.
Right, but nobody was hurt, right? Here, nobody was hurt because the contractor fixed everything so quickly.
Your Honor, I take a different point from that. Nobody is hurt, thank goodness, but an elevator shaft was left open, a gaping elevator shaft. So someone could have been hurt. And that, I think, gets to a related point to Your Honors, which is, and my brother makes this point in briefing, that there were no damages associated with the negligent supervision of the renovation project. So I do want to say something about that. The first is, there may not have been monetary damage that the jury awarded, again, because thank goodness no one actually fell down the elevator shaft, but that does absolve the contractor of what they need to.
But the consequence, let's say it out loud, the consequence of your rule, I think, is that the owner can walk away from this deal, this contract, and not have to pay the $1 million that he owes.
I disagree.
Okay.
The contractor always has as a remedy quantum meruit, which the SJC explicitly said in G4S. Scanland didn't bring a quantum meruit claim here, but that is available.
Fair point. But my response to that would be, so why does this matter? In other words, if we agree that he's entitled to $1 million on quantum meruit, why are we here?
You might agree that they're entitled to $1 million in quantum meruit, but that's an equitable theory. And in that case, the court would be assessing the relative clean hands of the parties, and I think the SJC walked through this both at oral argument in that case, and then again in the written decision itself. That provides flexibility in terms of a damages amount, but it's not commensurate with a breach of contract claim. The only other point I'd make, Your Honor, on the negligence count not resulting in damage is that harm is a required element of negligence. So in order to have found negligent supervision of the renovation project, the jury did find harm, even if they awarded no damages, because again, thank goodness, no one fell down the elevator shaft that was left open.
Okay, I understand that.
I just want to make sure I'm understanding what you're saying, going back to the waiver issue. Put aside G4S for a moment, okay? I'm looking at your answer, 8th affirmative defense. JKS's claims are barred by its own material breach of the contract. At any time in the course of the case, was the supervision clause identified as the basis for the material breach of the contract?
I don't know if it was explicitly identified as a basis for the material breach, but it was explicitly referenced in the counterclaim by
The
provision A.
negligence. I'm saying this is an affirmative defense to JKS's claim in contract. I'm looking at it right now, okay? Is there any point in this, can I find anywhere in this record where as a defense to the contract claim, your client identified the supervision clause?
I'm not aware of a record citation for that.
What's your best case for the proposition that the verdicts are legally inconsistent?
I have a few. National Lumber versus Welch. But I would also point the court to cases like Cacciavale and Hayes v. Arian, all situations in which inconsistent verdict and the resulting judgment require remedy. And the question then is whether that remedy is direct entry of judgment on that count, like National Lumber, or the De Feliciano case, which is cited, I think, on page 41 of our brief, or whether the remedy is a new trial.
Okay, let me see if there's any further questions. Seeing no further questions, thank you, counsel.
Thank you.
And counsel for the appellee.
Good morning, Your Honors. May it please the Court. Seth Passakarnas with Hinckley Allen. With me at counsel table is Attorney Lindsay Peterson Black, co-counsel at trial, as well as on the brief. I would like to address 5 points with the Court this morning. The first point is that the trust has waived its right to appeal by failing to object to either the jury verdict or the jury instructions at trial. The second point is that the court, if it considers this appeal, the scope of the appeal is very narrow and it is limited to Scanlan's breach of contract claim. The judgments entered against the trust also included fraud and promissory estoppel, and damages were assigned to both of those counts in the amount of approximately $1.5 million. Those judgments cannot be disturbed as they have not been appealed. The third point that I want to address with the court is the practical implications of the entry of judgment on those two counts, fraud and promissory estoppel. According to this court's decision in Ken, based on those findings, the G4S analysis does not apply, and I will get to that. The fourth issue that I want to address is the standard of review of a trial court judge's ruling on a post-trial motion, which is, of course, abuse of discretion. There was no abuse of discretion here. The trial court judge issued a very thorough and well-reasoned decision following the trial. And the last issue that I want to address is that the trust makes an argument that the jury verdict here manifests an error of law, a latent error of law. And here there was no error of law. The first issue is that the trust's appeal is barred by its failure to object to the jury instructions and the jury verdict. There are two clear, undisputed facts. The jury was instructed exactly in accordance with their proposed, and the trust never objected either to the jury verdict or to the jury instructions. These two undisputed facts are fatal to the trust's appeal. In Massachusetts, the law is crystal clear that any perceived inconsistency in the verdict, either factual or legal, must be objected to timely before the jury is discharged. Otherwise, an appeal on that basis is waived. And the rationale for this rule is important and it is sound. Inconsistencies in jury verdicts can be addressed immediately, as Your Honor pointed out. The judge can resubmit questions to the jury with additional instructions or submit supplemental questions that can clarify any perceived inconsistency. But the failure to object deprives the judge of the opportunity to do that, and that opportunity is forever lost. The law on this particular years, this court, the appeals court, has issued 3 decisions comprised of 8 different judges dismissing appeals on this very basis. So this court should find that this appeal is waived. If this court allows this appeal to continue, it will weaken the law. It will open the door to new appeals. It will marginalize 2 fundamental principles, which is the importance of timely objections to preserve appeals and the conservation of judicial resources.
If it's a latent error of law, what additional questions could the judge have asked the jury?
It's not a latent error.
I understand, but
law.
the argument is it's a latent error of law. So what purpose would it have done to object to the verdict?
The court could have gone back to the jury and asked questions to clarify whether the jury properly applied the G4S instruction. And that would have clarified that there was no error of law. The fundamental issue here is that the trust argues the provision in a construction contract is per se a G4S provision. And that is not correct. The trust is wrong about that. A contractor's contractual obligation to supervise the work is not a per se complete and strict performance requirement. And the way that we know that, there's two reasons that we know that. One, the purpose of the complete and strict performance requirement, which we get from G4S, and second is the application of that standard. So first, if you look at G4S on pages 731 through 733, the SJC explains very clearly that the purpose of the complete and strict performance requirement is to ensure that construction work is performed in accordance with design specifications. Now, the trust, as they argue here today, would have this court believe, as they argue in their brief, that the purpose of this requirement is job site safety. They refer to safety of construction projects, safety of the work site, safety of construction projects, and job site safety in their brief. And they do this to try to persuade the court that the importance and need for strict compliance with construction law contracts to ensure that the construction itself is done safely and correctly according to design specifications. That's the one sentence they cite. At the end of that sentence, the SJC cites to Russo, which is a 1947 case involving the construction of highway barriers. And in that case, the specifications required 4 pins to be installed in each highway barrier. The contractor only installed 2 or 3. And the court in that case noted that the failure to install the proper number of pins compromised the strength of the barrier. The SJC in that case never even actually uses the word safety. It's not until 2018 when the SJC reviews G4S and they cite to the Russo case, they cite to the Russo case as failure to follow design requirements and guardrail posts posed safety problems. Okay. But what G4S makes clear is that the complete and strict performance requirement is to build the project according to the design specifications. And that concept is clear from the next 2 sentences in the case.
So I'm sorry to interrupt you, but
Yes.
are you arguing that a contractor's supervisory role is a question of law or a question of fact for a jury, or it depends?
It is a question of fact for a jury.
In all cases?
Yes, Your Honor.
So the jury is supposed to, well, first of all, how do you reconcile that with the notion that contract terms are generally decided as matters of law in the first place?
Correct. The trust in this case cites to 2 cases for the proposition that this is an issue of law that the court should rule on, the Eigerman case and the Cady case. The Eigerman case stands for the proposition that interpretation of a contract is a question of law, and Cady stands for the proposition that conflicting terms in a contract is a question of law. But here we have neither. There's not a contract interpretation issue. There's no conflict in the meaning of the contract. The contract says what it says. The ultimate issue is the application of the facts to the contract. And that is entirely within the province of the jury. So the jury is correctly instructed on the law. They apply the facts, which we don't know what all of the facts and all the evidence are until the end of the trial. And then the jury applies those facts to the law. This is no different than when a jury is instructed in determining materiality in a breach of contract analysis.
Right, but here the jury has to make a determination, at least it's my understanding, as to whether this relates to construction or not. Where were they instructed actually that they had to make that determination?
In the jury instructions, there's a clear instruction on G4S that says something to the effect that because
Looking at
Scanlan...
Record Appendix, Volume 3, page 430, it says, with respect to Scanlan, because Scanlan is a contract under law, it must show complete and strict performance of all the contract's claims that relate to construction. With respect to any terms of the contract not related to construction, Scanlan must show it did not commit any material breaches of the contract. Is that what you're referring
Yes.
to? that doesn't really say to the jury, you're the ones that have to determine if it relates to the contract or not. I mean, if that's the guidance we're going to give juries going forward, the question's never really answered. It's never really asked or posited. That's something I'm struggling with if this truly is going to be a jury question. In other words, I wouldn't want this as a model instruction. What I want might not matter. But I'm not sure that we as a court would want that as the model instruction to go to a jury to make this critical determination.
And how I...
So what kind of, I mean, assuming we find no waiver or decide to make this determination, I would hate to say that, yeah, the instructions here were sufficient.
Well, there's 2 points on that, Your Honor. One, the instruction is exactly what was proposed by the trust in this case, and they never objected to that. So it is what it is in terms of the instruction. I would argue that that instruction is clear and consistent with the law in G4S. And I would say that the jury, in the way that they applied the law, shows that they understood that. In my opinion, the jury shows that they were thoughtful about how they went about all of the facts in this case and how they did assess that there was a negligent act, but that did not cause any damage. And so I do believe that that instruction is consistent with G4S and it is proper.
Where does it tell the jury that it has to make that determination?
That instruction is within the instruction to the jury about how they are to apply the facts to the contract. That instruction continues on and talks about the materiality standard within the confines of the contract. So I do think that if you read the entirety of the jury instruction on that issue, it is clear that the judge is instructing them on applying the facts to the contract.
It talks about materiality. Does it also talk about complete and strict performance and what that actually means? I don't think that's ever further explained anywhere.
It's not further explained than that sentence in the jury instructions, Your Honor. Going back to why we know that this is not a G4S per se strict and complete performance provision, the next 2 sentences in G4S explain exactly that. It says, "This is particularly true as defects are difficult to identify and expensive to fix in a finished project." And the next sentence is absolutely critical. "Thus, we have not tolerated any breaches that relate to whether the construction was completed according to design specifications." After that sentence, the SJC cites 7 cases. All 7 of those cases deal with a contractor's failure to implement the construction exactly in accordance with the specifications. None of those cases, address supervision or safety. Not one of them. So it's therefore clear in G4S that the purpose of the complete and strict performance requirement is to make sure construction is done properly. The second reason we know this is because in footnote 16, the court gives an example. It talks about how certain construction provisions are supportive to actual construction, and it identifies the payment clauses in construction contracts. And it states, "If, however, a subcontractor, having not received timely payments, installs an insufficient amount of highway guardrails, uses plaster of inferior quality, or does not complete the project, such breaches would be analyzed under complete and strict performance." In other words, a fact finder must assess, using the complete and strict performance standard in that instance, whether the work was actually properly performed in accordance with the design specifications. So when we read G4S as a whole and those 7 cases which it cites to, it's clear that supervision is not a per se G4S provision. The proper analysis, as I said, is at the end of the case based on all of the evidence that is presented to the jury. And I would ask that the court not be persuaded by the trust's attempt to expand G4S beyond its clear limitations in this case.
I'm a little bit confused. So you said it's not a per se G4S provision. When would it be a G4S provision?
Well, if the court looks to footnote 16 in Exhibit G4S, footnote 16 gives an example where you have a supportive provision, a payment clause that requires a contractor to make timely payment to a subcontractor. That's not a G4S provision, that's a supportive provision. Similar to the supervision clause. However, the court then says, but if you breach the payment clause and you don't timely pay subcontractors, and that as a result of that, they then use inferior products, or they then cut corners and they don't build the project correctly, then you're looking at those breaches through the lens of
Those are
complete-
separate breaches.
Yes.
So the payment clause is never a G4S provision, right? But if it results in separate breaches that affect the actual construction of the project, that would be a G4S issue.
I would agree with
Okay, so I mean, I guess I'm not understanding, what I understand you to be saying is it's not per se, it's a question of fact for the jury. I don't understand that. Why isn't the standard that the jury is supposed to apply to what is alleged to be a breach of the contract? Well, that's a question of law, and the judge should instruct on that, right?
Yes, and the instruction is, if it is a contract requirement that pertains to performing the work in accordance with the plans and specifications, the contractor has to comply with that strictly and completely. If it is a supportive provision, it is governed by the materiality.
That's a question of law, right? So let's say that the trust had said, Scanland can't recover its argument, let's say its argument was, and it had been raised to the judge, Scanland can't recover on its contract claim because they breached the supervision clause of the contract, okay? And that's the argument, that's the defense. The judge would determine whether that clause was a G4S provision or whether it's governed by the materiality standard, and then the judge would have instructed the jury, if you find that Scanland breached the supervision clause and that the breach was material, that forecloses Scanland from recovering on the contract. Isn't that right? It's a question of law.
I would disagree.
Okay.
The legal instruction to the jury is proper in that the jury is instructed if it pertains to the actual construction, complete and strict performance. If it's something else, use the materiality standard. The court should not delve into a 1,000-page contract and identify specific contract provisions and say, this is G4S
No,
provision,
the court
this
shouldn't.
is not.
The parties should. The parties should identify the provisions of the contract that they're relying on to foreclose the contract claim, and then it's up to the judge to determine which legal standard applies to those provisions. The jury doesn't decide that. Right? The jury is not supposed to take a provision of the contract and say, oh, this relates to construction, and therefore we apply G4S, or doesn't relate to construction, so we apply materiality. That's a job for the judge, right?
Well, I would analogize this to just a simple breach of contract case. In a breach of contract case, the judge instructs the jury to use the materiality
Right.
rule. And that is what the jury does. They look at all of the facts and the alleged breaches, and they determine whether in that contract it is a material
Whether it was
term
material as
or
a
it was
question
not.
of fact, but the actual standard, whether it's materiality or strict and complete performance, is a question of law. Are you saying it's a question of fact? I'm not understanding.
I'm saying that the determination of how to assess a breach of contract in a construction contract, whether it is a complete and strict performance or it is a material breach, that's to be determined by the jury.
Okay.
Based on all of the facts and all of the evidence.
And your best authority for that is?
Is, one moment.
Apart from the undecided portions of G4S.
Correct. I would cite the court to the case that we cite in our brief, which is DiPietro versus Sipex Corp. 69 Mass Appellate Court 29, which discusses the concept of whether a material breach has occurred as a question of fact ordinarily to be decided by the jury. And using that logic...
That's not a case telling the jury to determine the standard. That's different, right?
Correct. It's telling the jury to apply the legal standard to the facts, and that's what we're doing here.
Okay.
Thank you, Your Honor.
Thank
We
you
rest
both.
on our brief.
It's
Appreciate
a
it.
difficult case, well argued. We'll take it under advisement. The case is submitted.
Thank you.
Calling our next case, let's call it Doe v. SORB 23P 1323. Attorney Bartman, nice to
Yes,
see you.
Good morning. Good morning, thank you. Good morning, Your Honors, and good morning, Attorney Greenaway. May it please the Court, I'm Frederick Bartman, and I represent appellant in this matter. The crux of this appeal is that there is insufficient evidence to find by clear and convincing evidence that my client is either a moderate risk of reoffending or that it would be reasonable to find that internet publication of her status as an offender would protect against reoffense in the public in general. And in this particular case, the initial opinion from the hearing officer relied heavily on factor 2 to make his determination that my client was at risk of reoffending. And we know by Superior Court finding from Judge Wilkins that was not appealed, that it's no longer applicable to a case like my client's. And appropriately, the initial Superior Court review, that judge remanded it to the hearing officer for an important determination that he was required to reevaluate the evidence without factor 2, given that my client has no burden, that the burden is on SORB by clear and convincing evidence, and frankly, without factor 2, there is almost no other evidence to suggest that my client is at any risk of reoffending. And so...
Well, the SORB lists or cites a number of factors that the hearing officer in turn cited. And so, for example, factor 3 and factor 9 and factor 19 and factor 25. Let's just take the last one, prostituting a child. I guess the logic on all of these is that these factors, the legislator or whoever, or the reg creators have decided, create a higher risk of reoffense. And so they say that well, go ahead.
Sure. No, thank you. And but in his decision on the issue of reoffending, he relied on factor 2, factor 3, her prior use of alcohol, and discounting the opinion of Dr. Guidry for a number of reasons that he cited that I'd like to comment on shortly. He did not, in terms of the reoffending piece of this, look at factor 25 or I think either 9 or the other one that Your Honor just made note of.
19.
He was very succinct in his finding in terms of reoffending. And when you take away the idea that the number of times he did this and that she did this and that she had ample opportunity to reflect on wrongdoing and nevertheless continued, that has no bearing on reoffending. The number of times this occurred has no bearing on reoffending. Her receipt of money in the circumstances of this particular case has no bearing on reoffending. That what we were left with is factor 3, the fact that this was a prepubescent child, and prior use of alcohol that he applied minimally given how little evidence there was of its current application to her behavior, and that he minimized and discounted the opinion of Dr. Guidry in terms of the risk of reoffending. Dr. Guidry cited in her report and during her testimony to aspects of the CMRs that list these factors that the hearing officer frankly ignored, and that he's required to consider, and yet he ignored them in discounting.
Can you remind us what specifically was factor 7 one of them, but which factors did he ignore?
In terms of ignoring Dr. Guidry's opinion and underlying science, it is in the preamble to all of these CMRs that females reoffend at a considerably lower rate than men. It is in the CMRs that the tests that have been developed and all of the studies of male reoffending do not apply accurately to women, and that there are other means by which their chance of reoffending can be assessed. She applied what was required of the CMRs. She took that into consideration. She utilized tests that highlighted that my client is not suffering from any antisocial traits, that she doesn't suffer from a mental abnormality, and that while you can acknowledge the horrificness of this crime, including repetition, including that it was her own prepubescent child, there was nothing in the evaluation of my client or in the science or in the testing that in any way suggests that that bears on the issue of reoffending.
I want to go back to the first issue you raise.
Sure.
Which, as I understand it, is fundamentally that the judge, or rather the hearing examiner, in his decision after remand, although he removed consideration of factor 2, essentially put it back into factor 37, right?
Yes.
So let me first ask what I would call a housekeeping question. The hearing examiner removed all references to compulsive or compulsivity except for one, what I'd call extraneous reference at Record Appendix 144.
Sure.
The SORB contends that that was likely a clerical oversight. Would you agree with that?
Well, for sake of argument, I am going to agree with that, because in a way it makes my point. He hit the delete button. This is not a reevaluation, and so he missed this one reference.
So with that in mind, I'm looking at General Law, Chapter 6, Section 178L1, which says, the board shall consider any information that it deems useful in determining risk of reoffense and degree of dangerousness posed by any offender. That seems to me is the basis, for factor 37, the reg, which looks at other information related to the nature of the sexual behavior. Here's my question for you.
Sure.
Why can't repetitive conduct, not compulsive conduct, but repetitive conduct, in this instance, 3 years of repetitive conduct, 20-plus instances of allowing rape of her child to continue, participating in it, etc., why can't that go to factor 37? Are you arguing it can never go to factor 37, or are you just arguing that here they put it under factor 37 with no meaningful analysis?
Well, it's kind of the latter, Your Honor, because I'm not saying that it might not have some substantive analysis under factor 37, but the crime is the crime. And in terms of the analysis required on remand, on the fundamental issue of the risk of reoffense, repetitive conduct is not relevant.
But I think the hearing examiner said he applied it to dangerousness, and there's no indication he applied it to risk of reoffense.
Correct.
So why was that incorrect?
I don't think moving it to factor 37 was incorrect. I think it was redundant, not helpful to the analysis, that in the end analysis, he didn't do any re-examination of the first element for which clear and convincing evidence is required. What is her risk of reoffending? And when you remove the compulsivity and the repetition of the crime from the analysis, what you were left with in his redacted version of his original report is slight use of alcohol, factor 3, and discounting Dr. Guidry's report. And I do want to mention factor 3 before I lose time to do that. I'm not arguing that this is not a prepubescent child or that on a technicality or a box check that factor 3 is met. What happened here, this hearing officer not only checked that box, but he then attributed enhanced risk under that because she's a prepubescent child, despite the fact that there's absolutely no evidence that my client suffers a mental abnormality or any kind of sexually deviant ideation. And that's what factor 3 says is required before you give enhanced risk of reoffending elevation to that element. And it just
didn't hearing counsel concede? Didn't hearing counsel concede that factor 3 applies?
Could you repeat that, please?
Didn't hearing counsel concede that factor, is it 3? Yeah, factor 3 applies at the hearing.
Did the hearing officer?
The hearing counsel.
Oh, hearing
Doe's
counsel?
Yes.
I guess by way of not arguing it specifically, he didn't. I guess I'm not saying it doesn't apply either. It's like what I'm saying is that factor 3, as applied to the facts of this case, was simply a box check. There wasn't any analysis of how does that actually provide evidence of her risk of reoffending. This was a single intrafamilial child that once she was apprehended, there's no evidence of repetition of the behavior. And again, to just highlight the hearing officer's indifference to real analysis beyond the box check, he applied increased risk to it, even though there's no evidence that she was suffering from a mental abnormality. And the final point about not only factor 3, but all the evidence in this case is that even if you concede a moderate risk of reoffending, which I do not, and even if you find a moderate degree of dangerousness, which is frankly hard to dispute, and why it's okay to throw it in factor 37, where is there any evidence that internet publication is going to provide some level of safety to the public on the specific facts of this case? And that's where the minimal applicability of factor 3 comes into play. The fact that it's an intrafamilial victim comes into play. The fact that this hearing officer gave no consideration to Dr. Guidry's opinion, in which you have embedded things that he is required to consider, such as her gender, such as the tests about reoffending that would be applicable to females, and the science, the number of articles that look to the near non-cognizable risk women pose for reoffending once caught. So without that proper analysis on remand, we have arrived at a classification that is not supported by clear and convincing evidence. Thank you.
Thank you, counsel. Attorney Greenaway.
Good morning, Justices. Attorney Roxanne Greenaway, representing the board. First, with regards to Factor 3, I raised that it should be waived, the argument should be waived because it was not raised below. But even putting that aside, Your Honor, as I mentioned in my brief, hearing counsel did concede that it was a prepubescent child. You can find that in the record on S414.
I have a global question. On all of these factors, it applies to Factor 3 as well. Okay, we all agree with the fact. The fact is this involved a prepubescent child. But it's clear, I'm looking at the hearing examiner's report. He's using it to support the first hurdle, risk of reoffense. So is there data to support the causal relationship for this factor? In other words, if the crime at issue involved a prepubescent child, therefore, the risk of reoffense is higher. And you could go through the same exercise with every single one of these. I understand he's obligated by the statute or the regs to consider that, and at the box checking, right, we have that. And I guess the reg tells us that is, as a matter of regulatory finding, a risk. But is there science that supports that?
Well,
and does that matter?
I would first point out that, as Your Honor points out, these are properly promulgated regulations by the legislature. When you look in the first part of 803 CMR 1.33, where it discusses the first 6 high-risk factors, you will see cited in there the different articles that the board relies upon to indicate that it indicates research supports that the strongest predictors of sexual recidivism for all offenders are the variables related to antisocial orientation and sexual deviance. And then it goes on to discuss that these factors are basically connected with heightened risk and heightened dangerousness. The first 6, we're speaking specifically about the first 6 high-risk factors. Now, naturally, you can always look at the facts of the case in applying the particular factors, and any of the particular factors that the hearing examiner is going to apply. With regards to Factor 3, when you look at the regulation, you're looking at whether or not that child is of a prepubescent age. That's where the heightened risk comes in, the extra heightened risk, increased risk, I should say. Weight is given to that factor when you are not only sexually assaulting a child victim, but you're sexually assaulting a prepubescent child victim.
I get that, and you've answered my question very well, that there is scientific research in the CMR supporting the first 6 factors. I understand what you're saying, and that's helpful to me. Thank you.
Thank you. And so with regards to Factor 3 and the facts themselves, that's why I point out that hearing counsel saw the facts of this particular case and in the record concedes that Factor 3, that this is a prepubescent child. And so that factor, there was never a question before of whether this factor applied or not.
So let me ask you about Factor 37.
Yes.
Are you making the argument that any time someone's sexual conduct is repetitive, they've offended more than one time, that it is a factor to be, it falls within Factor 37 without limitation?
I'm going to say that I will always leave that up to the hearing examiner to decide the particular, because I don't think if you have 2, Factor 37 applies. I don't think it's that straightforward that a hearing examiner says if you have more than 1, I'm going to apply Factor 37. In this particular case, and I think that's what we have to focus on, right? In the facts of this particular case, there is no doubt that Factor 7 would apply, because you have someone that has sexually assaulted this child over a 3-year period. And so you do have to look at the repetitive conduct.
So what are the limiting principles on that? In other words, when does it fall under Factor 37? When is repeat conduct not enough?
I think it's always going to be a case-by-case basis.
It's going to be
and it will always be subject, obviously, to review. Again, I point out in my memorandum, DO 360651, where the appellate court on a Rule 23 decision had a similar issue and indicated that while you cannot consider that repetitive conduct under Factor 2, based on those two sentences that were invalidated by the declaratory judgment, you certainly can take that behavior under consideration in regards to Factor 37 as to dangerousness. And the court points out, for example, in dangerousness hearings, the court looks at the repetitive conduct of a person. So there is basis for that.
So why couldn't there be why not have just a standalone regulation that that adds repetitive conduct as a standalone factor?
Well, I don't write the regulations. However, I would indicate that we do have the properly promulgated. And when you look under Factor 37, I think it is a factor that some may refer to as a catch-all, where you can, the other things that aren't specifically addressed amongst the other factors can necessarily be considered under Factor 37 if it's related to the sexual offending behavior.
Can I ask a follow? Oh, sorry. Go ahead.
Just one quick follow-up,
Sure.
which actually goes to Justice Wood's earlier question. Is there a scientific basis to put repetitive conduct under Factor 37? Is there science underlying the notion that repetitive conduct speaks to dangerousness, period?
I don't know that. First, I would point out that there is no law that indicates that all of the board factors necessarily need a scientific basis in order for them to be valid, right?
Right, but I'm asking as to this one.
Right.
Is there any scientific data or basis or report that suggests, it seems like it's common sense, arguably, but is there any scientific basis
Well, I'm just going to give you
for the notion that repetitive conduct goes to dangerousness, period?
Not that I am aware, but I will point out this again, and this is why I'm pointing out how Factor 37 works. Because in this particular case you have Factor 2, and I would point out that the boards are revising the regulations. I'm not saying that that's going to necessarily come out to be a separate factor. However, at the time that this case came about, the 30A appeal was filed before the declaratory judgment was decided. So we have to look at it under that lens. This case was pending when that case came down. It wasn't remanded because the hearing examiner necessarily made an error. It was
When
because
you say when that case came down, you mean Justice Wilkins' case?
Correct, DO 22188. When that declaratory judgment was issued, this case was already pending. So the judge was at the 30A had to send that case back because that was no longer good law. So that's why this particular case was sent back, not because there was an error necessarily, but because the declaratory judgment was issued during the pendency of this case.
Sorry,
Now,
I didn't understand. It was an error. Of course it was an error, because he relied on something that the SJC determined has no predictive value in the repetitiveness of he started, as your brother points out, he started his opinion with the repetitive nature of the crime. And the SJC says that's not, and Judge Wilkins later say, that's not relevant. And so clearly it was an error, right?
Based on how the law developed is what I'm saying.
But it was an error. He was wrong scientifically.
At the time.
And then the law chose to follow the science. And so it was an error both as a matter of law and of science, right?
I will say that based on how the law developed, at the time he decided that the law was it was allowed at that time for it to be decided. That's why I'm saying he didn't make an error at the time based on there was a law that was established and then he went against that. What I'm saying, at the time he made that decision, that was not yet law.
He was following the law at the time.
And then the law, during the pendency of the case, the declaratory judgment was decided, and then it was decided that that is error and must be
I have a different question on Factor 37. The hearing examiner, in his opinion, breaks down two categories, as he's supposed to, risk of reoffense and degree of dangerousness. He cites Factor 37 in both. I understand your brother to be saying, arguably dangerousness, the repetitive conduct is relevant to Factor 37 as dangerousness, but it's not relevant to risk of reoffense. But the hearing examiner, in his do-over, says, I'm considering Factor 37 to risk of reoffense, but he doesn't clarify what in that catch-all. Do we know what he's considering?
If you look at the hearing examiner's decision,
right, that's what I'm quoting. It's R145 is where I am.
It will indicate to you that in the application of R1, it starts from R143.
Yep.
And it goes to R145.
Yep.
The first part, starting on R143, there he indicates he's discussing the articles that were submitted, right? And then when you go over to R144, he separates it and says, I also note. Now, when you go to the discussion portion of the decision, where he's discussing the risk and the dangers on R145, he's very specific that says, under the risk part, I considered the articles submitted under factor 37. And then when you go to the dangerousness part on R146, that's where you have the discussion.
Repetitive conduct is,
Right.
it only goes,
To the
under factor
dangerous.
37, only goes to dangerousness.
Thank you. Yeah. But I have another question now. I was pondering your answer about factors 1 to 6. So I cited factor 3, and you said factor 3 is supported by science in the regs. Right. But factor 2, which we've now said, at least the last 2 sentences of, is not supported by science, is one of those first 6 factors. So are we, I'm confused. So the science doesn't support factor 2, even though it's one of the first 6 factors, and the regs list a bunch of scientific articles that purportedly support these factors.
I'm going to say that if you look at factor 2, the old factor 2, right? It has different portions. The declaratory judgment was very clear as to what it was invalidating. And that is when someone has repetitive conduct and a time in between to reflect on the wrongfulness of their conduct. That's not what we have here. That factor 2 is not even considered in the amended decision. We're not looking at the fact that there was no time to reflect in between. We're looking at the repetitive nature and the dangerousness that would befall a future victim were Mrs. Doe to reoffend. So we're looking at 2 different types of inquiries when you're looking at the risk and the dangerousness.
Okay.
Could I ask you about, sorry to jump around, back to factor 3. So there's no dispute the victim was a prepubescent child, so you can check off the box. But I think what your opponent is arguing is that, so factor 3 says that offenders who target prepubescent children are more likely to have a deviant sexual interest. And I think what your opponent is arguing is that when the facts of the case show that perhaps that's not applicable to this offender, doesn't the hearing examiner have to do more than simply check the box?
Well, I'm going to first say that they're not checking a box. When you look at the discussion of factor 3 in the hearing examiner's decision, and throughout the whole decision, the hearing examiner is very particular as to why certain factors apply. Now, again, I go back to this whole waiver argument because the board is expected to now come before the appeals court and answer these questions.
I understand, but just going forward, I think, when you have a set of facts, you have a female offender. I understand the regulations address female offenders, but you have a female offender, the victim is her child, the perpetrator is a third male party. It seems to me the hearing examiner should be obliged to do more than simply say factor 3 applies. Therefore, higher risk.
I don't think, again, the risk and dangerousness is not necessarily decided by one particular factor, right? It's going to be, the hearing examiner is going to look within the record and see if that there's substantial evidence within that record to support the application of that particular factor. Now, having said that that child is a prepubescent child, when you look to it, I understand the justice's indication about that they're more likely to have a sexual deviance, but the board has no burden to go and show that this particular person has a sexual deviance. What you do have to show is that the facts of this case in the record is supported.
But where you have an expert who's saying she does not have a deviant interest.
That's one of the things the expert says. But then you have to look at the overall expert opinion and the different grounds that the hearing examiner uses to disagree with that. Now, one of those is that the expert indicates that factor 1 doesn't apply. that would just be an inapplicable factor. The law is clear that when you have a factor that does not apply, it does not go to risk or against, it doesn't go to the offender or against them. It's not weighed at all. It's the same argument with the fact that we mentioned that the victim is intrafamilial under factor 7. It's a non-applicable factor, so you do not look at that. But you do have within the expert opinion, the hearing examiner indicating that she applied offense-free time in the community when it clearly does not fit within the regulations. She accepts the hearing examiner, and they're in that position to make that discretionary decision about the minimization, acceptance of the minimization of the sexual assaults. And the hearing examiner goes to the different factors that...
I'm sorry, I'm going to have to stop you there, but let me check to see if there are further questions from the panel. Nope. Seeing none, I'm going to have to stop you there. The red light's gone off. Thank you, counsel.
Thank you.
Appreciate your arguments, and the case is submitted.
I appreciate it.
Calling our final case on the list, docket 24P320, Thomas v. Cunningham. And we will hear first from, Attorney Clark.
Good morning. If it pleases the court, my name is Robert Clark, and I'm appearing on behalf of the appellant, Jerry Cunningham. I guess I should apologize somewhat in advance. I've been working on...
I'm going to have to ask you to speak up, counsel, please.
I've been working on what could it best be called a shoestring budget. But, and I guess secondly, in the interest of economy, count one regarding my client's inadvertent direct distribution of or after-tax funds from an IRA. I think we can step over that. Not conceding any of the merits, however, actually litigating that, although we contend that there was a measurable benefit conveyed by way of foregone income tax liability. Actually determining that liability would prove to be a nightmare, and the cost of litigation certainly would would likely be multiples of the actual benefit. In any event, going to the court's treatment of
but you're not conceding any arguments on that count?
No, I simply would prefer to focus my time on things that we can actually resolve. And I guess in that regard, I should apologize because I do practice in the probate court, and that is a court of equity. And there, the general goal is to reach the greatest good for the greatest number. And the rules are somewhat loose. But going to the court's treatment of the motion to dismiss with respect to count 2. First, her finding regarding the elements of unjust enrichment, and that appears in her judgment, pages 8 and 9, which is page 39 of the appellant's brief, relying on the factors she recites from Tedeschi. First, Mr. Thomas clearly conveyed a measurable benefit to Ms. Cunningham when he transferred his home equity to her. Now,
can I stop you? And
go ahead, please.
So I'm looking. This is a motion to dismiss. We're appealing the allowance of motion to dismiss, and so we have to go to the complaint, your complaint, which you drafted. So I'm looking at your complaint. I'm looking at Record Appendix 77. I'm looking at paragraph 13, and in that complaint, you represented the following: in consideration of the father's requested reduction of his support obligation, the parties stipulated that mother would refinance the mortgage. Can you go to the stipulation and show me evidence that that was consideration for the mother refinancing the mortgage?
not within the four corners of the
So
stipulation.
is it true?
Is it true that he expected?
not what he expected, that they, in consideration, that's contract language, in consideration of the father's requested reduction of his support obligations, the parties stipulated that the mother would refinance the mortgage and he would convey title to her. In other words, he's giving her his equity in the house in exchange for reduction of support. Is that, obviously she's disagreeing with that now. Is it true? If the stipulation doesn't speak to it, so was that true?
That is what the trial court determined.
No. I'm asking, did your client, you and your client, think at the time you were entering into the stipulation that it was in consideration for giving her the equity was in consideration for her agreeing to reduce the monthly payments?
Yes, but at the time we were unable to reach full agreement on that point. As to the language of the stipulation.
Okay.
That was, of course, entered on the date of trial. We submitted pursuant to Section 78, and with regard to any notice that Ms. Cunningham had of my client's expectation of compensation, that was clear not only from his Section 78 submissions, which I believe are page 170 of the appendix, but also
clear from your client's Rule 78 submissions.
Yes.
Right. In other words, his arguments, what's the evidence that there was a meeting of the minds? I think you just said there wasn't actually a meeting of the minds, but what's your evidence that there was a meeting of the minds about the exchange that you're proposing, that he would give over the equity in exchange for her agreeing to reduce the monthly payments?
That may have been somewhat loose language on my part, because really the expectation was that the court would enter a judgment in his favor, which in fact it did.
Right. Thank you.
And based in part on that consideration, the court obviously, he had requested a monthly reduction of $1,750. The court gave him a reduction of $1,710, and also converted it from unallocated family support to spousal support, which would have done two things. I think the most important of which would have been that it really would have precluded any further litigation, particularly with respect to the emancipation of the children. As my brother knows, we've been engaged in that modification for nearly 2 years. So there, the benefit that he received by virtue of the vacated judgment is pretty easy to determine, and that's a future value from October 23 of 2020 up until September of 2026, when he will reach full retirement age for Social Security purposes.
Right, but we're talking about unjust enrichment. That's your count, right? Count 2, unjust enrichment. So what's the evidence that she reasonably she believed that he expected this benefit that you're talking about?
That expectation manifested through his further pleadings and the court's judgment.
His pleadings. What's the evidence of her awareness that he expected this?
That's more difficult. However, it flies in the face of the entire record to suggest that she was not aware of any such expectation. It had already been adjudicated, and the house had been ordered to be sold in April of 2017. He had refrained from pursuing that in the interest of keeping the kids in the Lincoln-Sudbury School District, eventually seeking to retain the master's services to sell the house in the summer of 2019. We still might have some discovery to do in that regard, but Judge Anthony was unable to get Ms. Cunningham's cooperation at that time, and they eventually entered into the stipulation.
What do we do about the statement in this court's earlier opinion that the stipulation and the modification judgment were not intertwined? Why isn't that preclusive now?
The court statement that the stipulation was not predicated on a specific outcome, or was not predicated on the judgment because the judgment entered 3 months later, kind of elides the fact that the judgment certainly was predicated on the stipulation, at least in part. And the two prongs supporting the modification were the emancipation of the party's oldest child and the conveyance of the equity.
Wait, but the court said that the judgment was not predicated on the stipulation was not predicated on the outcome of the modification complaint.
It was not predicated on any particular specific outcome,
Yeah.
but the judgment itself was predicated on the stipulation, which had entered as a partial judgment.
But, so, I mean, you're essentially asking for the stipulation to be unwound, right? Is that what you're asking?
No, and I think there were certainly all kinds of practical reasons for the original panel not to unwind that transaction. And I guess in retrospect, we found that it probably would have been substantially easier. She did refinance the mortgage through a family member and appears not to have been paying on it since the time she took over the house. However, that does not alter the fact that she did receive a measurable benefit, whether that benefit is measured by the judge's finding of $71,000 or some other calculation of the value of the house at the time. Going to the question of res judicata, and the court's relying here on Coburn. Well, I guess I have to say that in the first instance, we've always been taught that you state the facts, you state the law, and then you apply the law to the facts. I could quibble with some of the court's recitation of the facts, but with respect to the elements set out in Coburn for issue preclusion, obviously the claims are substantially different. One was essentially seeking to enforce a judgment, and the other here is seeking compensation for unjust enrichment. Now, the identity of the parties, absolutely. Was there a final judgment on the merits? Well, to the extent that there's a partial judgment, or a significant portion of the judgment, which I do have to say was intertwined with the stipulation, since one relies to or the judgment relied upon the stipulation. Yeah, there was, and it was vacated in relevant part. Whether the issue of the home equity was essential to the underlying judgment, well, yes, but again, that judgment was vacated. And I think it would be certainly intellectually dishonest to view in the wake of the reversal of the judgment, to view that stipulation as simply a gift, which it certainly should not be.
Can I ask, assuming we disagree with you on the merits of all of this, I noticed that your opponent asks for fees. If you're in the world where you've lost on the merits and we're considering a fees application, you haven't filed a response to that claim. What's your argument that they're not entitled to fees?
This matter was brought in good faith. And obviously the reversal of the underlying...
Let's start with the first count. Yes. The first count, which you, I guess, want to walk over. I don't know what good faith means in this context, but it seems to me that there were at least two clear rulings that the IRA tax implication was not something that your client's wife should have to bear. And yet, and within 5 days of the last decision by the appeals court, you filed this complaint in the face of those clear rulings. What do we do with that?
Well,
why is that good faith?
What we do with that, we were not actually seeking to have her bear any additional tax liability. Ideally, and this matter obviously started in 2019, and despite, well, on one hand, Ms. Cunningham was complaining about having received this lump of money rather than a deferred retirement asset, based on communications with the fund manager, we could have reinserted it and basically reversed that whole transaction. She consistently refused, and then By the
Courts
time-
have ruled that she didn't do anything wrong. Repeatedly, they've ruled that. So I don't understand how that is relevant to your claim that you had a good faith basis to bring this third attack or fourth.
Well, first, as a matter of the claim is different. Originally, we had simply sought specific performance.
Yeah, the core gripe is clearly the same. How is the core gripe different? I guess it's fair to ask a question. I don't think that distinction that you just raised is relevant.
Otherwise said you could have brought an unjust enrichment count at the same time earlier, correct?
No, that was not our intention. We were actually seeking her cooperation and basically restoring the original status of the
But you could have
transfer.
brought the claim. I understand you chose not to for perhaps strategic reasons, but you could have brought it, correct?
I guess we could have, but, and I would not say there were really strategic reasons. I think it simply would have been contrary to the economic reality of the underlying transaction to seek restitution at that time, since all we really needed was to restore basically the status quo that the judgment of divorce had anticipated, which would have been a tax-free transfer from one retirement account to the other. And the error happened prior to my involvement in the case, and unfortunately, I was unable to get it resolved. With respect to the question of fees, well, we're still here, we are still litigating, and at the bottom of it, particularly down below.
Your time has expired, but I'll let you finish your
Well,
your
down
thought.
below, I mean, if the standard, and, you know, I will just say up front that I believe that the Rule 11 claim was simply schoolyard stuff. But if the standard pursuant to Section 231, Section 6F, is wholly insubstantial, frivolous, and brought forth in bad faith, we cannot see this because, honestly, I still have a very difficult time seeing that the trial court properly applied the standards for collateral estoppel, at least with respect to count two.
Seeing no further questions, thank you, counsel.
Thank you.
We will now hear from counsel for the appellee, Attorney Loomis.
Thank you very much, Your Honor. This case is an extraordinary one. I've faced many arguments that I think are wrong, that are foreclosed. I have never before sought sanctions against an opposing counsel or an attorney in any case before this one. And the facts of this, I think, illustrate why. We're now 8 years, more than 8 years, after the divorce judgment entered. And for over the last 5 years, Mr. Thomas, and represented by the same counsel, has been waging a scorched earth litigation campaign against my client based on the exact same facts over and over again. And a year and a half into this scorched earth litigation campaign, when my firm agreed to represent her pro bono, he began to lose these claims. He lost the contempt judgment. That was both claim preclusive and issue preclusive because the Chief Judge Monk ruled in the Probate and Family Court that my client shall not be required to pay any tax. To the extent that Mr. Thomas is now contending that she was unjustly enriched and must disgorge the amount of taxes that she avoided, that is a direct collateral attack on that ruling as a matter of issue preclusion, but also as a matter of claim preclusion, as your questions got at. It also illustrates and defeats the reasonable expectations, which is why it appears that Mr. Thomas has now abandoned this claim on appeal after forcing us to brief this in the trial court, attending 2 different motion to dismiss hearings because at one point the judge recused herself, briefing this again in the appeals court, and prepping for this argument with the expectation that they were going to contest this issue once again. And then, just a minute, or less than a minute, into argument, we see him walk away from this claim because it turned out there was never any good faith basis to begin with. I would commend to the court's attention the last time, the oral argument recording from the last time we were up on appeal, because the same thing happened in that case. 3 minutes in to Mr. Clark's argument, when he was appellee no less, he conceded that the judgment below might have to be vacated. This is extraordinary, to have a party continue to brief issues over and over again after I have submitted letters, emails, had calls requesting that he explain the factual and legal good faith basis for this claim and gotten nothing in response. In fact, the only thing we got below on this issue was an argument, which he does not make in his appellate brief, but just mentioned in oral argument right now, that you cannot raise res judicata on a motion to dismiss. That is not true according to the Strawbridge case, the Lanier case, the Kavanaugh case, the Bigelow case. Those are all decisions that we cited below. I believe our reply brief was just one long string cite on this issue because it is plainly incorrect. And in fact, when we raised our concerns about these issues below, the only thing I got was not a defense of the underlying merits or an explanation as to why preclusion did not apply, things that I would have taken with great respect and real consideration. Instead, it was an email suggesting that my client, because this ultimately affected the children, as all probate and family court proceedings do, could potentially face catastrophic risks and consequences if there was not a settlement. Now, I understand all probate and family court issues are very contentious and very difficult. I am not disputing that. But when the response to a letter outlining the severe concerns and framed in Rule 11 terms about the lack of good faith basis for these claims, when the only response is to ignore the merits and instead say, well, if you continue to litigate, you're facing catastrophic consequences, I would respectfully submit that the only clear inference, or at least a strong inference one can draw from that, is that this is being prosecuted with a lack of good faith.
What is your authority for the proposition that pro bono counsel can obtain attorney's fees?
I confess I don't have a case on hand for that. I would respectfully, so what I would suggest, Your Honor, if it is in fact an issue of first impression, and I don't have a case on that in part because there was no reply brief filed, and so I didn't think that that would be briefed, and I certainly think it is a forfeited objection at this stage. But to the extent I may, Your Honor, if this court were to deny us attorney's fees in this instance, I would at least respectfully request that it be made clear in the record that the claims do fall short of lacking a good faith basis in this instance, at least to protect my client in future proceedings. Ultimately, I'm not looking to make money from this case. My firm is not going to make money from this case. We have spent hundreds of hours on this case in attorney time, both in the prior appeal and this appeal, in the contempt judgment, in the present case, which has a number of problems with it as well, and which we have not sought fees for, notwithstanding the very severe problems with it. The problem is that at some point, pro bono representation does have to end, and my concern is if we were to ever end a representation of this client, then Mr. Thomas would come back and bring the exact same claims over and over again. And my client needs some form of protection, even if it's only a nominal amount of fees, even if the fees are technically set at zero because we're pro bono counsel, which, to be clear, I don't think they should be, and I think it makes sense in part to preserve the integrity of the judicial system, to ensure that the fees are actually awarded in this instance, so it actually amounts to a real penalty against prosecuting frivolous claims. That's one aspect of it. I've been focused so far on count one. I'm happy to address any questions about count two.
I have a question about count two. So on the res judicata issue, you're relying on the footnote in the earlier court opinion. How is that essential to the judgment?
Oh, of course, Your Honor. So this is I'm glad you asked that. So in the restatement section 27, comment C, the restatement second of judgments, comment C, the traditional rule for issue preclusion is that when you have an appellate court that has two alternative holdings for its decision, then both holdings at the appellate level are in fact issue preclusion, even though technically they are alternative holdings for the same position. It's also actually essential for a particular aspect of his request in the prior appeal, because he specifically asked that if the judgment below were vacated, that he specifically have the transfer of the home equity unwound as well. And that's in the oral argument recording as well. Now, the appellate court's decision to not unwind the transfer of equity is itself essential to that footnote 12.
How is the claim for unjust enrichment equivalent to seeking to unwind the stipulation?
Because at least as I understand it, he is seeking to, whereas before he was seeking the equity back, here he is seeking the monetary equivalent of that equity. I think issue preclusion is broad enough in this instance to conflate both the equity and the monetary equivalent, because money is ultimately fungible. But note as well, Your Honor, that even if you don't accept the issue preclusion point, claim preclusion is even easier in this instance, because there you don't actually need to even have a specific ruling on the issue. It just needs to have arisen out of the same operative fact. And we heard before from my brother that there was no final judgment. The final judgment was vacated. Respectfully, that is not true. What happened in the prior modification judgment was he had previously brought 2 counterclaims, one for modification and one to force my client to sell the marital home. He then settled his counterclaim for modification, and then he subsequently settled the counterclaim for sale of the marital home. That's the waiver. That's when he waived the equity in the home. And then what happened in the prior case is that the trial court allowed him to Rule 60B his prior settlement of his modification counterclaim, reinstate it, go to trial, and get a new judgment. Now, the appeals court in the past appeal vacated that second judgment and ordered the probate and family court to reinstate the prior judgment that existed with an extremely limited remand. So I guess in that sense, yes, part of the case was there was a judgment that was vacated, but then it was sent back and reverted to the status quo. And the status quo can be found at R57, where there is a stipulation of partial judgment. And it's both entered into the court record, and it says judgment on it, and so it's a judgment on its own. But also, for what it's worth, claim preclusion can also arise from a settlement that the parties agree to, but that ultimately covers the same operative facts. This is something where, again, the specific request and ask was made of this court before. And I respect the point, Justice Shin, that maybe there might be concerns, that maybe there's some slight difference between the issues. But there's no getting around the fact that it was ultimately the same nucleus of operative fact.
But for claim, so I understand his argument to be now that, similar to what the court seemed to have rejected in the earlier opinion, that yes, there's a stipulation, but it was dependent on the outcome of the modification judgment. And we said in a footnote, no, we don't find them to be intertwined. But I'm not seeing, as with respect to that particular issue, how claim preclusion would apply. I mean, when would he raise that claim in the earlier proceeding?
Of course. So
versus issue preclusion.
So in the prior proceeding, he specifically said, I'm going to do the transfer of the equity, and I am going to specifically ask for my support obligations to be reduced as part of my modification counterclaim. And the court specifically held in 2 ways, both when denying the Rule 60 motion and vacating the Rule 60 motion, and then second, when holding the second part of the opinion that modification would have been improper, that the transfer of the equity in the home was not grounds for reduction of modification. So the way that he raised it before was by saying that because I transferred the equity, I want my support obligations reduced. Now he's saying because I transferred my equity, I want you to disgorge yourself of the value of the equity or something equivalent to the value of the equity. It's 2 sides of the same coin, and that itself is enough. But even if we don't get to all of that, I would point as well to Justice Wood's comments and questions during colloquy as well. You cannot have unjust enrichment from a contract. That is squarely precluded under longstanding law. I think you have to go back. I think you can go back to the 1830s if you follow the case citations and the cases in my brief. It is squarely precluded. And even if this were not an actual contract, even if he were attacking it for lack of consideration, which he's not, 1, there was consideration. He removed himself from the mortgage. That is enough. If an A court is consideration, removing yourself from the mortgage is consideration. Second, even if this were not a valid contract and judgment, it still would not matter because, as the Judge Posner opinion in the brief that I cite, the name of which is escaping me right now, but Posner J is specified, an unsolicited transfer of benefit is not ground for unjust enrichment. So even if he is now saying, oh, this was a gift, but I was hoping that it would ultimately lead to this, that would not be grounds for unjust enrichment either. And I say all this as, I'm sorry, Justice.
I just want to make sure the contract that you're referring to in that line, I followed it all, but what is RA 57, the stipulation, right?
Correct.
That's we're going to treat that as the contract for your analysis.
That's exactly right.
Right, go on, sorry, I didn't mean to cut you off. Go on.
No worries at all. And I'm happy to answer any further questions about the merits. In terms of the request for fees, which my brother calls, quote, schoolyard stuff during his argument, respectfully, a collateral attack on prior judgments, by my count, no fewer than 4, the divorce judgment, the contempt judgment, the dismissal order of his original equity complaint, and this court's prior decision, and ultimately the settlement itself, and I'm conflating those last two as a single one. That is truly extraordinary stuff that does not happen very often. It is truly extraordinary as well to be warned about Rule 11 consequences to an attorney, not to a pro se litigant, to an attorney about the Rule 11 problems of collaterally attacking multiple judgments, and to get no substantive response other than just the incorrect assertion that I don't need to respond to res judicata on a motion to dismiss. Which, to be clear, even if that were true, that would not be grounds to show that this had a good faith legal basis. Because then the question is, okay, well, what's the plan at summary judgment? What's the plan at trial? And the fact is, there never was a plan. The plan was to harass my client and coerce her into settlement. That's why there have been multiple 2 contempt actions filed during the pendency of this appeal by my account, both of which lost. The second one, as best I could tell, was the first time any private lawyer has filed a criminal contempt claim against another private litigant in any of the state courts in Massachusetts, which is part of the reason why it lost. These are truly unusual circumstances where there are truly, and I don't use this word lightly, I do not use this word in any of my briefs lightly, in fact this is the only case I've ever done so, there are truly frivolous claims and frivolous legal theories being asserted in this case. And I understand and take the point that this court might think that there might be concern with some of the arguments raised, they might think that there might be some good faith basis about 1 or 2 arguments in here, but the test for whether or not appellate attorneys' fees and costs and interest is allowable under the Avery decision and under the Ellis decision, which I cite in the red brief, is not whether or not there is 1 or 2 valid arguments or potentially valid arguments, it's whether the appeal as a whole is valid. And when my brother gets up and immediately knifes the first part of both of our briefs, I think that is a very strong indication that we are in that territory. I'm happy to answer any other questions the panel may have. I'll otherwise rest on my briefs.
Seeing no further questions, thank you. Thank you, counsel. The case is